All right. My apologies for the late start. Yeah, man, I just want to apologize for that. I'm 20 minutes, late, so to speak. But all the thing goes sometimes, it's more about time and space permitting. So I just want to apologize for that still. The thing, we appreciate and we value the time of our viewers and subscribers. So we not take things for granted. You understand me? I say big up on yourself. It's Tuesday, June 11. It's 1:50 p.m. Eastern Standard Time. I just want to say welcome to the channel once again. All the thing of people. Just hit that like button on your way in. Yeah, we greatly appreciate the support. I think the hardest part of me being on YouTube is to get people to really hit that like button, even the subscribers. You get what I'm saying? So just hit the like button. Yeah, man, it does help the platform. It's a very small platform, but it is also one of the most potent on YouTube. You know what the thing go. All right, let me go through the formalities, and bless up the ones and ones. And please, just if you're a new subscriber as well, or a first time listener, just drop a comment in the chat so I can big you up. You understand me? I say, because that is how we do it. Yeah, man, we big up everyone that supports the platform. Lone Star, big up yourself. Island Spice, big up. BI Strong, bless up. Bridget, big up yourself, Haunted Official. Yeah, man. Anything going on Haunted Official, I'm going to have to step out and just hold a little reasoning and get some perspectives. Manners and respect me, general. Big up yourself every time. Chef Fox. Big up in a Chef Fox. Manners and respect me, general. Yeah, man, you know what the thing go. The Vendetta Chief of Staff. Miss J Detta, anyway, there, my sister, big up yourself, you know what the thing go. Yeah, man, Miss Julia, greatly appreciate the first super chat. Miss Julia said, we'll be very informative. I know, bro, can't call in, but we'll be listening. Yeah, man. We know the thing go, Miss Julia, man. Big up yourself. You get what me I say? Ricky Tan, big up my general. Manners and respect. Jerome Young, big up yourself, Manners and respect, me general. Private Figure, big up yourself. Boxer Dan 123 Vendetta, big up yourself, Canon God, big up, Chang, manners and respect, me general. Fully Gaza UTG, big up yourself, me general. You know the thing go, Global Life Records, big up, You know the thing go. Nicky Willie, big up yourself every time. Cute Browning, where you going with? Yeah, man, bless up, Cute Browning. Respect for the check-in. Let me see who else there, big up to Orient Computer 5K. Yeah, man, big up yourself. Let me see who else there. All right, because I got you, Merkaba 360. Manners and respect, me general. Big up yourself. Julius Diamond. Big up yourself, me general. You know what the thing go, Jeremy and A. Simon. Yeah, man. Big up. Respect for that, Chef Fox. Yeah, man. Just make the ones and ones them know, say, we just go and like up the stream. Because you know how the thing go. Yeah, man. We greatly appreciate the support as always. And that's how it them in general. So respect for that. Michelle Clark. Big up yourself in the Michelle Clark. Silver One. Big up. DJ Congo. Big up yourself. Dead D, where you going with Dead D? You know, some manners and respect in a Dead D every time, You know what the thing go, The free thinker, manners and respect every time, in general. You don't know it, go big up yourself. Rick Storm TV, big up, me general. Taya Campbell, big up yourself. Dancehall Vybz TV, big up me general. Respect for the check-in. First time seeing this person. Garcho 876, big up, Jerome Pearson, big up yourself, me general. I know anything going on. Yeah, man. Jerome Pearson, at the Gaza general in the building. I know anything go. Ricky and a chief of staff. But big up the ones and ones. You know anything go, man. Let me see. Sylvester said, bless up. I always tune in and listen to you guys. You guys doing a good thing. Yeah, man, Sylvester. We greatly appreciate those words of encouragement. Well on there, 1 second there. Self-made. Yeah, man. Manners and respect, you know how the thing going, big up yourself. Ryan Scott. Yeah, man. Big up yourself, So you know what the thing of people, we have 80 people in the building. Remember, just drop a like on the stream. Yeah, man. And you know how the thing go, you know how we do it. You know how we get to work. It's all about solid, constructive conversations. Yeah, man. And we're here to hear different perspectives and, hear what the ones and ones have to say as it relates to the conversation. Let me just big up the members as well, quick and fast. Exit 9, Alfred Russell, Dada Stereo, Lynette Thompson, Mark Chang, Ray Blay, Anti Official, Sonic Frequency Sound, Mandela Strength, Canon God, Naquan, Silver One, Ocean Johnson, Is Addiction, Cute Brown in Beast, Text 876, Skyboss Game, Jeremy D TV, Not Nice, Cara, Time Will Tell, Success Over Hype, Michael Brown, Lee Miller RTV, The Skeptic, Ever Blessed, Black Saldi, Eakan, TG Media, Private Figure, Jamon, Bayoni All, Humbleman RB, Lone Star, Michelle Clark, B.I. Strong, Sweet P, Global Life Records TV, Rick Livestream, The Free Thinker, Nicky Willie, DJ Congo, Not Your Child Car, Moodman, Rayan Williams, Only Good Karma. Big up to all of the ones and ones who are members, of the channel. I want to say thank you all for supporting the platform. All right, so also remember, yeah, man, the link is pinned at the top of the chat. So you know how the thing go. Ones and ones can always check in and give their perspective. Today is day 2 of the Vybz Cartel Court of Appeal hearing. Yeah, man, and we see some interesting things unfolding. So you know how that go. We definitely have to speak on these things. So I just want to touch on this one quick and fast because I find this to be very interesting as well. There are 3 more days left, so there's definitely a lot to really unpack, and there will be a lot that will be unfolding, right? So this article here now is a very interesting one because I think the defense, yeah, man, they are arguing about the admissibility and inadmissibility, etc., etc. So I just want to read this just to add some context and some clarity to the conversation as well. And it says defense lawyers representing Adidja Vybz Cartel Palmer and his co-accused are contending that the unavailability of technological material that was used in their original MR trial will affect their client's defense if a retrial is granted. So what they're arguing to say that the unavailability of the technological material, so they might talk about the forensic analysis of the phone and things like that. So they are arguing that, so it being unavailable will definitely impact their ability to mount a strong defense if it is supposed to go back to a retrial. Let me continue. While the attorneys have submitted a report from an expert witness in support of the claim, the prosecution, the DPP, is objecting to the document, challenging it as hearsay. Very interesting. The prosecution has further contended that the expert witness, IT consultant Sean Wenzel, has presented an opinion outside of his expertise. Very interesting, people, because the DPP is saying that the IT consultant Sean Wenzel, is presenting opinion outside his expertise. So it would be just like, say, me now, I give an opinion and a medical report, in terms of, say, putting it to the court when, I am not a doctor. So that's a very interesting point that is being raised by the prosecution. Court of Appeal judges Justice Marva McDonald Bishop, David Fraser, and Paulette Williams are presiding over a hearing to determine whether the men, Palmer, Sean Campbell, Kahira Jones, and Andre St. John, are to be retried or acquitted in the 2011, dirting of Clive Lizard Williams. They have reserved a ruling until the matter is fully hashed out in the substantive hearing, pretty much, which is to start today. I remember when the judge said, school start yesterday. So the judge was speaking in the context of, say, orientation and things like that. And we see the judge said today, say, school end. So at the business times, today, henceforth. Let me continue. The objection was raised by Assistant Director of Public Prosecution, Janek Forbes, who cited 3 issues with the affidavit submitted supporting the report. Are we talking about the forensic phone analysis by, the IT specialists? Forbes argued that the report does not conform with what the law stipulates and also addresses the expert's review of the report, which is not included in the affidavit, and on that basis said it would be considered as hearsay. He purports to give an opinion on that phantom report, and secondly, he purports to give his opinion on the effect of pre-trial publicity, Forbes said, noting that the expert has attempted to provide his opinion on a matter outside of his knowledge. Intervening, Justice McDonald Bishop pointed out that the scope of the court's consideration does not include assessing evidentiary material. Very interesting point there. Let me read it one more time. Intervening, Justice McDonald Bishop pointed out that the scope of the court's consideration does not include assessing evidentiary material. So the court has said, boy, them not there to assess the evidentiary material. Isn't this a case that the court could well take judicial notice of? That it has gained widespread publicity? Is that contested? Because the question is whether the pre-trial publicity is a ground for barring a retrial. That is what we are here for, she said. Very interesting. Attorney at law John Clark, however, submitted that the legal precedent has established that material which could help in determining the issue should be considered, hence the importance of said report. Consequently, he noted that the expert has ascertained whether the defendants would be prejudiced by the delay in relation to any expert analysis of the technological evidence. What we are saying is, if there is a retrial, it will be impossible for the expert to analyze some of the technological evidence for the defense to have adequate facilities to mount the defense's case, Clark stated. He pointed to examples, including JS1 material. And JS1 have to deal with the whole cell phone settings, which was unavailable to the defense during the trial. The data from both telecommunication service providers, which had a 1-year lifespan and would now no longer be available to the defense. This is very, very interesting right here, because the JS1 is really the forensic analysis carried out by the IT specialists. And what they're saying is that it only have a 1-year lifespan, and that 1-year lifespan, is no longer valid. So that's very interesting, because I know people would argue, and I was thinking down that same line prior to hearing this, that the JS1, which is the forensic analysis of the phone, to prove that the phone was tampered with and there were inconsistencies with how the information was, obtained and things like that. The lawyer is saying that the 1 year lifespan is now out the window, so it would be difficult for the defense to have some solid argument about that JS1. That is very, very important, because if we all remember, they were trying to argue that matter, that the phone that was used, Vybz Kartel's phone that was used as evidence, was compromised. That's what they were saying. And, a lot of things were tampered with in the phone. The court never accept that. The Privy Council did not accept it as a submission prior to their hearing. So that is very important. Let me continue. Responding, McDonald Bishop indicated that Clark was rehashing matters that were brought up by the case and were not addressed by the Privy Council, while emphasizing that the appellate court cannot determine admissibility of evidence or weight. Listen that keenly, people. Justice McDonald Bishop indicated that Clark was rehashing matters that were brought up by the case and were not addressed by the Privy Council. And that is in the context of JS1, which is the forensic expert analysis about the phone, right? While emphasizing that the appellate court cannot determine admissibility of evidence or weight. Very interesting. But Clark insisted that one of the factors that will militate, I don't know if they wanted to say mitigate, against a fair trial, I mean, it can be interchangeable, I suppose, right, is the unavailability of technological materials. I agree, Mr. Clark, here, so, because that JS1 analysis is crucial. I think it's very, very important in the defense of Vybz Kartel and the co-accused. What we are saying is, in assessing this material, we firmly believe that this report and the material refer would assist the court in answering many factors and answering the ultimate question of whether the appellant's right to a fair trial and to adequate facilities to prepare their case will be affected by the delay, he said. Noting that the purpose of the report and legal standing on the retrial must be clear, McDonald Bishop reserved a decision on the issue until it has been fully deliberated in the substantive hearing with supporting authorities. So she has reserved, her decision on this matter until more than likely probably Friday or so. Forbes' objection followed an earlier preliminary objection raised by Acting Director of Public Prosecutions Claudette Thompson, who asked the court to strike out several portions of the defensive affidavits, noting that some of the pleadings were argumentative and speculative, irrelevant, hearsay, or a legal argument. The prosecution's objections, which took up the entire day, also saw the Crown abandoning challenges to several areas of the respective affidavits. So this is very interesting too, because the Crown, and we know how that got through the DPP, is not challenging certain aspects of these affidavits. So, those affidavits, based on what is being said here, more than likely might be accepted or admissible. Among the portions that were struck out was an argument from Palmer's son that he would not be able to stand another trial because of his illness. The court ruled that the son was unable to make such a determination without support from a medical expert. And that's the reason why last night I was saying that it would have been better if it was the medical expert who was presenting this argument as it relates to, Vybz Kartel not being able to withstand, another trial based on his medical condition. Anyways, the court, on the other hand, ruled against rejecting arguments from Campbell's sister that the men would not be able to get a fair trial because of wide-scale publicity on the matter by bloggers who have been spreading false theories and influencing negative views on the case. You know, they matter about Serpi and other bloggers, but you know how the thing go. In the meantime, the appellate court has indicated that it has requested an update on all the cases which have been sent back to the Supreme Court for retrial in the last 6 years. The judge noted that the update will be among factors considered in deciding a retrial. Very interesting too. The hearing is expected to last for 5 days. And, I think that kind of, sum up a brief synopsis, as to what is being conveyed here. So, my purpose is to really add some clarity, for the audience, so as people can really get a clear understanding or at least a perspective as to what is being said here. All right, so let me see who else there, so I can bless you up quick and fast. Wait. 232 people check in bright and early. Respect for that, people. All right, let me see what I go on now. Big up to Hannibal in the building. Yeah, man. Big up to James Bond in the building. Big up yourself. Big up to Miss Perfectly Imperfect. Yeah, man, you know how the thing go. Only good karma. Big up Apostle James. Silver One. Big up yourself, anyway you're there. Colin Burton. Big up yourself. D. Anna. Manners and respect. I just want to say big up, the Jamaican massive, Caribbean massive, North, South, Central American massive, European massive, Africa massive, wherever you are, watching this stream. Yeah, man, big up yourself. You can also represent where you're from. Silent listeners, you can also represent where you're from. Just drop a comment, let us know where you're from. And we can big up, man. You know the thing go. Big up to Ian. Big up to Kirk. Kimo Dancehall Clips. Yeah, man. Big up yourself. King Uzziah. Big up yourself. All right. So based on what I just read a while ago, very interesting arguments. The JS1, very, very interesting. So the defense is arguing about the admissibility of the JS1. And when they talk about the JS1, they're talking about the phone evidence. And I think that is very crucial in this matter. Because at the end of the day, if the defense can prove that the phone evidence has been compromised, right? That means that they can also validate the inadmissibility of that phone evidence. So people, remember, you can hit that StreamYard link. You can check in, give your perspective. We are open and receptive to engage in constructive dialogue as long as you keep it respectful. Let me see. Godfrey Goldburn, big up yourself in there. You know what the thing going on. Dwayne McKellar, yeah, man, big up. Yeah, man, D. Anna, manners and respect. So as I'm saying now, as it relates to the JS1, that is like a big SSP for the defense, because that will prove that the JS1, which is the phone that was used, if it is proven that it is compromised, that means that that device should not be used in any retrial in terms of evidence. So the defense are really trying to argue, say, well, here what? This JS1, we really need it. However, after a 1 year time span, yeah, it is no longer valid. And we know how that go. A whole heap of years pass and gone. But at the end of the day, we are just here to, just to update and to inform and to share the perspectives. And we can also reason it out and definitely hear what the people have to say. you know, just drop some likes on the stream, people. We greatly appreciate that. You know, we have 82 likes so far. Yeah, man. I think we can do a little bit better. 201 people in the building. You know how the thing go. Tolati big up. The phone was not tampered with. You have to use the phone when you're accessing it. But Tolati Blake, you would be challenging the forensic expert, right? Analysis. And Tolati Blake, you would have to prove to us that you are qualified to make such utterances. Because at the end of the day, public opinion does not supersede an expert's analysis. And if you remember very well, they were trying to get that JS1 to be admissible in their arguments at the Privy Council. And they were also trying to have the Court of Appeal at the time, you know, accept the JS1, you know, whatever. So at the end of the day, Tolati Blake, that phone, yeah, man, unless you are an expert analysis as the person who did it and has the evidence to show that there was tampering, yeah, man, I don't, well, it's more like you being a village lawyer like myself. So I saw it go. Big up to Ian, you know what thing going on. Yeah, man, Silver One, Kansas City. Big up to the Kansas City massive, you know what the thing going on. Jamar Alvarez, big up Belize City. We log in. Free world boss. See the people? Yeah, man, you have Gaza fans all the way in Belize. So the thing no normal. You know how the thing going on. So big up to the Belize massive, you know, and wherever you're from, man, just drop a comment in the chat so we can big on you up. Because we know say this thing here global. You get what me I say? You know how the thing go. Let me see who is there. Anthony Johnson. Yeah, man. Manners and respect me general. You know what the thing going on, man. We just there. I go and reason with the people, man. I share some perspectives. Also, I'm asking everyone to engage with the poll. You know, there's a poll that is in the chat as well. Yeah, man. Please just engage with that poll, right? And so we can definitely gauge the audience perspectives as it relates to the topic of the poll. Well, Ian, at the end of the day, you know, right? At the end of the day, Ian, that's up to the court to decide. And that's something there with this. I'm not too emotionally invested I try to throw out some things out there. You get what me I say? Let the court decide who did it and who is guilty. That's just the reality. The way the matter was dealt with, the Privy Council proved that you know, it was a kangaroo court settings in terms of that tainted juror. And when we say tainted juror, we can speak in the present tense in the context of what the Privy Council said. Because I know people will push back and say, but there were provisions in the law that accommodated that juror to sit on the panel to maintain the quorum. Yeah, we agree with that at that time. However, the Privy Council ruling supersedes that decision that was made. And as such, we can confidently speak in the present tense to say that juror was tainted because the Privy Council says so. Sandra Eslap, as me saying, man, me know say the Justice League people I go, you know, look on things one way or the other. But at the end of the day, it's up to the court to decide that. It's not me. You understand me? I say, you know how the thing goes. So big up. Bob Weeks, yeah, man, big up yourself for the check-in same way. Is addiction. Yeah, man, is addiction. Respect for the check-in, you know. Yeah, man. Canon God, yeah, man, we there go and observe the space, you know, and remember, you know, we have to be depending on the mainstream media to put forward the information. So they are the ones who are privy to the information. So as them drop the information, then we'll definitely see what's going on. Let me see. All right, so Sandra Bennett said she's from St. Martin, and she has said justice for Lizard family. So people from St. Martin checking in, different perspectives. That is how it goes. This is not an echo chamber. It's not a yes man panel. It's not a yes man platform. So we are here to express different perspectives. All I ask is that, you know, we just keep it respectful. We don't have to be disrespectful. We don't have to be condescending towards anyone. If you want to say something, yeah, man, you can always hit that link and check in and say, boy, you know, say me no like what go on here, so. And you know, say me no too rate where them say this, so. Yeah, man, and we are open and receptive to the dialogue. Jason Sharp, big up yourself in my general. Manners and respect. Yourself listening from New Jersey. All right, big up to Galactic. Yeah, man. Blessings from the UK. Big up all the UK massive, man. You know the thing going on. Big up to Chanel, Baby British as well. You know, big up to Kai Hype. You know, all the ones and ones in the UK. CKP, the mayor. Big up yourself. Big up to MB as well, anyway, you're them general. John Wick. Yeah, man. Big up, you know, Invest. Yeah, manners and respect, me general. You know, invested, there's almost a tangible tension on the ground. The public is on the side of the defendant. They are biased with the negative externalities when it's not in their favor. Invest, big up yourself, you know, as a law enforcement official, you know, so you kind of observe the ground and you get some first-hand observation. So I do understand. And we have to also understand, say, there will be for the defense and for the prosecution. So that's just the reality of things. You get what I say? I just that's all that there. John Wick, big up yourself. Duke, the Duke Sparky Melody. Yeah, man, manners and respect, me general. Big up yourself. All right, Bob Week say he's from Canada. Big up the Canadian massive, you know what thing going on. Janet Selby. Yeah, man, big up, respect for the check-in. You know what the thing go. Sandra Eslap, I love your channel all the way from England. Thank you very much, Sandra Eslap, for the words of encouragement. You know, greatly appreciate that. And we just asking ones and ones to drop a like on the stream, you know, as always. Yeah, man, only good karma. UK in the building. We know say a really good timing now for the UK massive. It's what? After 7? There and about? Yeah, about probably 7:22 p.m. in England. You know, normally, under normal circumstances, we touch out on the road at night time at 7:20. Most of the UK massive gone in bed. But you know what the thing go, respect for the check-in same way. Nick Ferran, yeah man, say he's from Canada. Shambodan from Canada. Big up, you know. Craig Burton, yeah man, big up. Him say he's from New York. So big up the New York massive. John Wick, I say he might represent Canada as well. Simon Miyoyo. The journey is so long and tiresome, but let's have hope that things will work well for Vybz Kartel. Yeah man, same way so Simon Miyoyo. And even though the journey has been long, yeah man, I think we are at you know, yeah man, the journey being to a point where we can say, yeah, man, you know, yeah, we are on the finishing stretch. So, couple more days, and we can definitely see what's going on. So, I just saw it go more than people say time fly like bird. Yeah, man, that go on. So, you know it go. Galactic. I really don't know the ins and outs, but if it was not for the juror, do you think Cartel wouldn't got non-guilty anyway? You know, say, me general, the jury did find them guilty. You get what me I say? Yeah, and even that quote-unquote tainted juror, he voted not guilty. And the other 10 voted guilty. So that should answer your question. Boxer dancer, so Imhotep, you know, see the video when Cartel planned the thing. As me I say in my general, you see, the phone evidence is being brought into question. I am not here to discuss the matter about innocence or guilt. That is up to the court to determine that. That's why I'm going to always say it, and I'm going to always say it over and over again. I'm going to reiterate it. I am not emotionally invested, right, where I am going to be judge, jury, and executioner in the context of things. I am here to look and see what the court is saying, and I will speak on these matters. So it's right there, some of them in general. Me, I met the court determine that because boxer done, me can have all the evidence of you doing something, but if the case is tampered with, you can get off of it. So at the end of the day, it's all about what? The law being adhered to and the legal principles and protocols being adhered to. That is just the law. Because at the end of the day, they were victorious in the Privy Council because it was proven for a fact that they did not get a fair trial, which is their fundamental right. So I am just here to speak on matters of the court, not my personal opinion. So respectfully, my general, I'm not to personalize this thing here. Nick Ferran, big up yourself, you know. FIFA done. Yeah, man. Big up, big up, big up, big up, big up. You know the thing, respect for the check-in. Yeah, John Wick, you know the thing more time as me say, you know, the hardest thing on the platform is to get people to really hit that like button. You know, yeah, man. But at the end of the day, yeah, man, for those who rate the platform and rate the reasoning, yeah, man, we know so automatically they will hit that like button. It's free, it don't cost you nothing. The type of reason that we present to the people is always some solid reasoning. So you know how that go. Tom Ford Top Man, yeah, man, manners and respect me general. You know how the thing go, you know. Respect me general. Yeah, 260. I whisper where they are now, 289 people there. So I just saw it go, my general, man. Who I like, just like, and that's it there. You know what thing go. We not force nobody to really like the thing. You know, who rate the platform and want to drop a like, we appreciate it. Who I watch from the bushes might not like the platform because somebody tell them, say, otherwise, then I just saw it go. Dr. K, yeah, man, big up, you know. Yeah, man, respect for the check-in. James, man, as me say, where they are observe things, man. Rick Storm.
Where are you with?
Yeah, man, where they are, you know. Yeah, man, where you going, general?
But situation, man, kind of a little bit busy. But I must try midday, well, not midday, but because I expect for hear a couple of people perspective, but once probably they are. How I late is now? Because I not even get to check in fully. Where do I go on?
Well, right now, still in a Rick. Right now, me see the Jamaica Gleaner, right? Yeah, the Jamaica Gleaner have a little thing I go on here, so, right? And it says that judge issues sharp rebuke of criticism of appeal court's delay in handing down cartel judgment. You understand what I say? And it says, acting Court of Appeals President Justice Marva McDonald Bishop has hit back at criticism about the length of time that the court took to hand down a judgment in the murder appeal brought by Vybz Kartel and his co-appellants. Defense lawyer John Clark, during his submission this morning, raised the issue while emphasizing that there were systemic delays in the criminal justice system. He said delays must be demonstrably justified so that the appellants can have a fair trial. And you know, as they would say, justice delayed is justice denied. So, you know, that I really go on. But I mean, you know, as time progresses, you know, we will always get the little update them. Kid, big up yourself, you know, Gregory Smith, big up. Poseidon, yeah, man, big up.
So I think about the little utterance where they teach me when I see in the newspaper where I say, being in prison, holding back from fully take care of him 17 dependents or something like that. I don't know if I see that article.
I'm sorry, where's Eric?
I think I don't know if I know the Star. There is an update where they must say Vybz Kartel I say being in prison kind of hinder him from taking care of him 17 dependents. I don't know if I see that part there.
No, I haven't seen that yet, but I mean that's a valid argument.
Looking at it. I don't know, look, can't you want looking at the Star or one of them thing, man? Let me look.
No, man, I'm bringing it up right now. I'm bringing it up quick.
Okay.
Yeah, man, I'm finding it still. As me I say, no. One would say that's a valid argument for him. However, at the end of the day, yeah, man, it's a cause and effect scenario, and the trial, you know, that cannot supersede or trump. You get what I say? These proceedings, but I think it's a genuine concern being raised. You get what I say? You know, all the
so you feel like the judgment I go subscribe to the argument, eh?
No, I don't think they would. No, I don't think they would, because at the end of the day, that will not be a mitigating factor, you know, as it relates to this hearing. Because watch this now, the court are gonna say, well, my general, a 14 years or 13 years, you're there behind bars and whatever, right? And yeah, man, the show I go on with your kids, them and whatever. So the prosecution will argue that, you know, and says that that statement is immaterial. But again, now we just there watch and see what go on. Big up to Shenette Edwards, you know. Manners and respect. Anthony Johnson, a big you up Rick Stam. You know,
yeah, me not even see chat, you know. So big up to all I want them with there, you know.
Yeah, man, yeah,
as
man.
me say, me kind of dip on a little Ray. So when I don't know anything, but so me have my phone, me just say me a check in, cause me not hear no thing there. But me understand. But yeah, man. So where you say you don't feel like that reasoning there is that strong enough reasoning for put forward for make no farm a difference?
No, the prosecution will push back at that still and say that that is immaterial, because it is proven that he has been away for a very long time in the context of things, right? And I mean, things are going the same way, so that would not be a factor that would determine, you understand what I say, him being released. But again, now we have to watch and see how things play out. You get what I say?
So based on observing how the thing look from like yesterday to now, when we say early now, we can't really use it as no absolute, nothing towards nothing. But how the thing look to you, Emotep, in terms of like even the judge, you feel like them operate fairly, or if you feel like there is any bias towards any side or nothing?
All right, the JS1, that JS1 is the forensic analysis report of the phone, right? By the defense to prove that the phone was tampered with and things like that. Now, based on the letter of the law, if that is proven based on the forensic analysis, it means that that phone cannot be admissible as evidence. But you know what the defense is arguing, that the time frame has passed for it to be submissible, and they are arguing that. So that is a crucial matter, because you know how it go. You know, all the ones who might say, you know, yeah man, no see when him plan it, and no see when him say what him go do, and no see when him video it. All of that came from the phone. So really and truly, if we put the phone aside, Rick, I think it would have been very difficult for them to get a conviction.
Sure.
You get what I'm saying? Also, they are arguing about the JS1. So if they are not able to rely on that JS1, that is a big SSP for them to not be able to rely on. You get what I say? James Bond, you must check back in, my general, whenever you can.
Yeah, man, it thing look kind of big up to all the people, you know. The thing look kind of, you know, the judge lady looks stern still, but you know, me think them kind of deal with it fair. I don't know if the fact that it went privy council and them know say everybody eyes upon it, and you have to ensure say, you know, all angles covered and whatever. And I think them want to make an impression that for sure say, well, the Jamaican justice system work as well, you know, because any little gimmicks and so forth, me see where them shut it down fast and I make them know say, yo, here I go on a serious thing, this I go on and say, you know, you see it. So stick to the argument and don't try to sway it here or sway it there. You get to me, I say?
Yeah, man, definitely. And I also think that the fact that, remember, you know, Rick, this is the same appeal court that sided with the previous ruling. You understand me? I say, so in reality, based on the Privy Council's ruling, it will be said that they have eggs on their faces. So them have to make sure so them cross all T's and dot all I's in this context, whereas nobody can say, but it come back to them again and then mess it up. The justice system, yada yada. So this the Privy Council ruling one is considered to some an indictment on the justice system. The CM appeal court, right?
Yeah.
No matter where it come back around 360 to them. So they have to make sure that they are doing everything as it relates to the rule of law, the letter of the law.
Yeah,
so
man.
Can't chastise them. You get what I say? So them know say them under the microscope.
But I like man, the system look sharp like razor, you know, based on what me see I go on. No joke from no side.
Right.
Yeah, man. Don't try to squeeze in nothing or whatever. Everything clear.
Right, yeah, because watch this now. When Vybz Kartel's son submitted his affidavit, I think it's a fair argument by the court to say, well, my general, we know say your father, you know. But you're not a medical doctor to tell us say him can't stand a retrial based on him health condition. So, you know, I think that's a valid argument by the court. And the lawyers them, you know, as we said, time will tell. But, you know, I would expect that an argument of that nature, you know, such a strong argument to present to actually, you know, validate against a retrial, it should be from the doctor. You get what I say? But
Yeah.
Hold on, General. 1 second there. Yeah, man, that is just my perspective still. Let's see it.
Yeah, man. Other ones there, them can't go through, you know?
Yeah, man. All right. So, me I beg on 10 seconds, please. Big up Nadia 369, you know, from England. You know the thing go. Big up all of the ones and ones. Them Lady Ann in the house. Big up in a Lady Ann. Manners and respect, my sister. Chang, big up to Israel. You know, yeah, man. Big up to Anthony Clark. Chronic Media. Big up my general. You know the thing go. All right. So, James Bond. Yeah, man. Unmute your mic and go through. Let me hear what I say. And then Kathy can say a thing after.
Yeah, man. Bless up. Based on what I am observing so far, I think this court has been very fair and balanced because I can't. Right. If I had to make a guess right now to say which way they'll rule, I couldn't do it because to me it looked like it's a fair and balanced thing that's going on right now based on what information is available to us.
Sure.
I would be satisfied with any decision they come up with because it looks. I couldn't say why them going to the DP because I don't have a dog in the fight, so I could look at it from a clear lens. To me, I don't see they're going towards the DPP, and I don't see they're going towards Mr. Palmer.
Sure.
So I like the way it is going and how it is transitioning. But with this argument that Rick brought up with the Cartel statement, that is utter madness. That you're taking care of 17 people, so you can't. If that was the case, you wouldn't get sentencing then. When they got sentenced, they say, boy, I can't go to jail because 17 people may take care of. I mean, like, but I understand their game plan. Throw everything against the wall. Hopefully something stick.
Yeah.
Yeah, just throw anything that comes to your mind. Because as you said, last night, for like not a doctor to come up and talk about someone's medical condition. Anybody that throw that out of court. Like, you're not a doctor, brother, you can't come say nothing. And we understand the emotional connection to your father, but the same thing. If you have a fluid, that's the same thing. So,
but you know what's James, man, not to cut your wisdom in general. I think, you know, that an argument of that nature, it's one of the strongest arguments the defense could present, you know, right? To say, well, based on the health, yeah, man, a retrial, he would not survive it. So, I mean, wisdom would dictate that, you know, yeah, man, the report be conveyed to the court by an expert.
In cases, the reason being why lawyers let the family member and those people talk last, so you will leave that impression on whoever making the decision. Even him going to say something like that, let him say that last. You don't open with that. That get lost in the sauce, no. You close with that if you want to play on the heartstring of the judges or the jury.
Right.
And that when they're about to make decision, you don't open your case with that. So I don't understand the method. Maybe further down in the week, they'll bring it back up again with the expert. But
as I said, James Bond, and you're right. You know, based on the observation, based on what me see I go so far, you know, I think it can swing anyway, brother. You know, there is no clear way if you say, boy, this is how it go or that is how it go. Me think say everything I run unbiased so far. you know, and
It,
what
it
decision is being made.
never lean to one, it never barely shift to one side. It's straight down the middle. It has straight cut.
Yeah.
Yeah.
One
Hello?
second, Miss Julia. Yeah, 1 second, Miss Julia.
Oh, sorry.
Yeah, man, no problem. I beg you a minute there. All right, let me make Kashi say a quick thing and then Miss Julia can say a thing after. All
One
right?
Miss Julia.
Yeah, man.
Yo.
Yeah, man. Go
Yeah,
through
man, big up, sorry,
Yeah.
big up.
Yeah, man, blessed. Yo, Imhotep, me send something in the chat a while ago. I don't know if you discuss here, but go over the
No, but hold on.
go over it.
Are you using the same name in the chat?
Yeah, man, the same chat me in for
Oh, you
click to
talking
come
about
on the live.
the
Yeah.
private chat?
Yeah, I think so. Yeah.
Right.
Just look on the link when I send it from the Observer, and if you can read, parts of it and see what going, because it really does look fair, based by even what the judge said. Just go ahead and read it.
Right. All right. So let me just share it on the screen. Right. So that's ones and ones can really see what's going on. Here. All right. So here we are. All right. And this is the Jamaica Observer, June 11th. Like this just dropped. Just dropped me, General. All right.
Yeah,
So,
it just dropped. Yeah.
all right. So the attorney argues breach of fair trial rights in Cartel co-accused Dirtin case. Attorney at law John Clark, representing co-accused Kahira Jones in the Vybz Cartel and others retrial hearing in the Court of Appeal, argued against a retrial, citing breaches of their constitutional rights. Clark contended that his clients, along with the others, had their right to a fair trial violated on 2 counts: their entitlement to a fair hearing within a reasonable time and their right to be heard by an independent and impartial court. Right? So he is contending these are the 2 violations, but the independent and impartial court, I don't understand why he would insinuate that the Jamaican court is not independent or impartial. But anyway, let me continue. Section 6, subsection 2 of the Charter of Fundamental Rights and Freedoms in the Constitution of Jamaica states that in the determination of a person's civil rights and obligations or of any legal proceedings which may result in a decision adverse to his interests, he shall be entitled to a fair hearing within a reasonable time by an independent and impartial court or authority established by law. Clark further argued that a retrial should not occur if it puts the accused in a worse off position than before, and warned that their rights were likely to be violated again if a retrial proceed. But Mr. Clark, right here, that is hypothetical. You get what I say? But let us continue. Justice Marva McDonald Bishop questioned the necessity of the retrial, noting that the apex court already found a constitutional breach. I know that them talk about the Privy Council. Why are we? McDonald Bishop inquired. What remedy do you give those persons if their constitutional rights have been breached twice? She continued. McDonald Bishop noted that the Crown will have to explain to the court why, in the light of 2 breaches, there should be a retrial. Very interesting. Cartel, Sean Storm Campbell, Kahira Jones, and Andre St. John, were charged and, the whole thing. So, pretty much he's arguing that, one, their right to a fair trial, which should be like, their entitlement, fair hearing within a reasonable time. Do we think that the time of this hearing was unreasonable?
No.
Right, because I think it is based on the Privy Council ruling,
right,
the matter remitted to the Court of Appeal. I think that this was very done in an expeditious
very
manner.
timely,
But
very timely.
But remember, Cartel.
But hold on, guys. Listen, James.
Remember,
Before you go again, let me just say something because I have to jump off. Right. So, first thing is first. Right. is a very, very fair trial. I don't see them necessarily going after anything political, like going after DPP or muddling the waters too much. I think it's very, very, very fair. That's the first thing. The second thing is, it's so funny that the same thing me and Vegas was talking about last night, about the fact that the strategy, what they're using, right, to make first about the medical thing, that, to me, that baffles my mind, because that was a very, very strong argument that the defense could use. That's number two, right? So I don't understand where what the strategy there is, because that it just don't make any sense, right? Because they could have really punched it. That's number two. Number three is, Rick, that thing that you sent me this morning, you sent me something this morning talking about the both of him talk about him can't take care of him 17 the dependents. That is a non-argument. That is a stupid argument. That is one of the reasons. That is one of the things that happen when you become incarcerated. Your family suffers. It is a part of the punishment. And also, if Lizard had 17 people depending on him too, guess what? They won't them can't get provided for either. So that is a non-argument. And he really, the fact that he said that, to me, gives me pause, because it makes me think, are you guys grabbing at straws here? Like, how desperate are you? Right? It's kind of, to me, when you pull up something like that, it make me kind of feel like, what really are you holding in your hands? Like, what you're showing your hand then by grabbing at something that is not substantial. To me, that is how I see it, right? It make me think that way. The third thing is, right, if them say anything about that phone evidence, man, that could be a real 180 turner, right? So let's see what's going to happen with all of that. But yeah, I agree with everything that what you guys are saying. And yeah, that's what I have to say. Okay.
All right, Miss Dula. Let me just say this, because he cited section 16, subsection 2, right, of the
Yeah.
Charter of Fundamental Rights. And they are saying that they shall be entitled to a fair hearing within a reasonable time.
But
Right?
this is fair. This is reasonable.
And so far,
Yeah.
we have not seen any indication that goes against the notion of not a fair hearing in a reasonable time. That is one, right? And then now the independent and impartial court. So he is saying that our court is not independent or impartial. At the end of the day, you know, he would have to prove that. You get what I'm saying?
Yeah, but
Imhotep is not independent or impartial.
But Imhotep, more than that, before we even Imhotep, honestly, that you're very thorough, and I appreciate that. But before you don't even have to dig that deep, because before you even go there, so think about it. The Privy Council did not just say he needs to walk. They were keeping his human rights in mind. That's why they were there. The fact that they said he has the potential to be retried means, basically, to me, and I guess if you guys have to think about it, it means that if he, in the case that he will be retried, it would not go against his human rights. Think about it. The Privy Council was there to look after him human rights. Them decide, say, you know what, his human rights were violated. Okay, fine. If they thought that him being retried again would further violate his human rights, why would they put that option on the table and say to them, okay, it's either you're going to let him go, or if you have a case, retry him? You understand what I'm saying? That would be that would be double binding them. So I appreciate your thoroughness, Imhotep. That's very, very true if you get down to it. But on the surface level, it not make no sense, because them, you understand what I'm saying? Them put it on the table, say retry him. So clearly retrying him, right, is not violating his human rights. And look at the time; it's been very timely. So I don't know. So that again, Imhotep, make me think, Rotted and really desperate. You're really showing your hand. You know, anybody who play poker can know that. Anyway, big up on yourself, and I'll see you later tonight. Later,
Miss
bye.
Julia, me never want you running now, come.
Oh, sorry. Okay. 1 more minute.
Oh,
Yeah, Miss Julia.
Yeah.
Me I say we have heated argument, not. We just make it clear for what me here last night. But
Okay.
here we go on now. Here we go on. What did he say? What did they say about the phone evidence? I heard something when Emmett Tepper reads about something it has expired. What has expired about the phone evidence? The original phone evidence or the rebuttal from the expert? What has expired?
All right. That's the JS1, right?
Yeah.
I remember the JS1 was the forensic analysis of the phone. You get what me I say?
Yeah.
Right? So
Okay, yeah.
Yeah, so
right,
they're
but
saying that it's inadmissible.
right. So what they're saying is that with the JS1 is a 1 year lifespan it has in terms of it being valid for admissibility, and that time has passed. So that is what they are really arguing. I get what me I say, Big Papa.
Yeah. So
Yeah. So all right. So the banking on the phone tamper with evidence would have come like it through the door, right?
Well, watch this now. Watch this now. The justice did say, right? Yeah, man, she did not dismiss it, you know. So clearly we will see what they say about this matter, because John Clark was arguing. You get what I'm saying? That the whole JS1, the fact that it is, you know, they have a 1 year window. They have a 1 year window. Yeah, man, that is not gonna help the defense. It's gonna work against the defense, because if they can't use the JS1 material because it is unavailable to the defense, right? Yeah, man, and the data from the telecommunication people is a 1 year lifespan it have.
yeah.
And guess what go on now? It would no longer be available to the defense.
Right.
That's a key thing right there. So
Very
Well,
because
then
key.
that makes it unfair.
I'm sorry.
I say, well, then that makes it unfair.
But
Because if the
again,
prosecution can use something, the defense should be able to rebut it. And if them can't, then that makes it unfair. That's why
no,
everything is up for discovery so everybody can plan.
yeah, but remember, say the JS1, the prosecution now use it, not true, right?
Okay, all right. But you were saying that it would go against the defense if it can be used. Isn't that what you just said?
Yes, but I am saying, but you are saying that we're good for the goose, good for the gander. That would insinuate that both of them might want to use it. I'm saying the JS1, right, is where the defense really would want to use to strengthen their argument.
Okay.
You know what I'm saying, General?
Yeah,
But
me get
what
it now.
I'm
Me get
saying,
it.
according to the law, after 1 year is a 1 year lifespan it have. So it won't be available
Okay.
to the defense based on that nature. So again, you know, the law really kind of take precedence with this JS1 thing here. So it's not like say somebody does circumvent or throw it out. But Miss McDonald Bishop, you get what I'm saying, was saying that they were really rehashing matters that was brought up by the privy, that was, you know, submitted
Okay.
to the privy council, and privy council said them nah look on the JS1 thing. So again, now me I go wait and see you know how that play out still. But that 1 year lifespan that pass and gone.
Pass
So,
on long
yeah,
time.
we have to just watch and see how that kind
Oh,
of
that play out. James, big up yourself, you know, James. Sorry for cutting you here. And big up on yourself, Big Papa, everybody. I'll see you later tonight. But when you think
Yeah,
about that,
man. Bless up,
that
Miss Julia.
argument don't make no sense. When you think about it, the dependent argument don't make no sense. The him rights them being violated again don't make no sense, right?
But Miss
None of
Julia,
them argument.
No,
how
I
much
think I
time?
think
How much
I think
time? How
hold
much
on,
time in this contact you say that, Miss
hold
Julia?
on,
So
please,
how
hold
much,
on.
how
Sorry.
much argument don't make sense so far to you? Make a count.
Hold on, please,
Tonight.
please,
Yeah.
let me
Tonight, we could do it tonight.
Miss Julia say what she has and cut no man,
Yeah,
please.
no man. Thank you, Imatep. Yeah, man. But Imatep, you honestly, you're a very deep thinker and you went very thorough. But we not even have to dig that deep to find it, because right now all of that thing what I'm talking about oh him rights being violated again by being retried is foolishness, because the Privy Council put it on the table for as an option, and they were looking at his human rights, and everything is being done in a timely manner. And the strategy is not clear. It's making me feel like as if them have some really bad cards just by what they're pulling at. Anybody who play cards or poker or chess can see that. I wonder about it. So, and also Lizard 17 dependent them not gonna get the money either. Okay, big up on yourself. Talk to you later. Bye.
Yeah, man, big up Miss Julia. As
but
James
kind of
Bond,
disagree with what she has said, to be
no,
honest.
about 1 second. I know you have to talk, man. Or yourself. As James Bond said, lawyers are gonna try and chew and see who are gonna stick. You get what me I say? Yeah, man, 500 people there, you know. Just drop a like on the stream if you want to join the panel. The link is pinned at the top, and also me just drop the link inside the chat as well, so you can hit that link and you can check in. Big up to all the ones and ones. And Big Papa, me just mute a while ago because your background kind of noisy a little bit. So just unmute and you're ready to talk.
Me I do a little driving. But go on, man. Go on, me listen.
All right, no problem. All right, I'm Kashi. Go ahead. You say you don't
No,
agree
may I
with
say,
Julia. Go
may
ahead.
disagree with Miss Julia say
Right.
because remember them attack previously what happened, right? Their rights were breached, right? And of course they're referring to the initial trial, everything from the trial to the conviction and them seeking hearing and all that. I think that's what they're referring to. They're saying if that happened before, what if it happens again? It can happen again. That's what they're saying.
General.
It's not saying it's not
Yes.
gonna happen.
Yes.
Hold on.
No, hold
Hear me
on,
out.
hold on. Me not give back the mic, man. But remember, I'm a general, right? When we are dealing with law, we can't carry hypotheticals in the thing. Not true.
I know, but
Go
this is
ahead.
what
Go ahead.
but so far it's to me it's still a good argument, right? Because think about this. What if she was saying, I think we are looking on it too deep. We still are looking on it like the man them still convicted. See? All right. So think about this. Look at it like this. She was just saying that I guess Cartel say, well, I can't take care, I'm 19 or 20, depending, whatever, right? And Julia raised the issue, say, hey, well, Lizard can't take care of him. Well, the thing is, you can't say that now because Cartel then get convicted again, where then they argue that at sentencing. Does that make sense? What they're saying now is because me have to deal with all of them, these dependents, I have to take care of them. I don't know if I can afford to go to a retrial. You understand? I think she's just looking at it from the surface. You know what I mean? Just think
Right.
a little bit deeper.
Right. And the thing is this too, you know, my general. If Vybz Cartel said us, you know, him can't take care and pitting them because of him situation. I mean, that is a
It's
good
valid.
argument for him to
It is.
present. It is up to the court to make that determination. You get what
Thank
I'm
you.
saying? So at the end of the day, my general, if I was in Vybz Cartel's shoe, I would have said the same thing too. And if Miss Julia was in Vybz Cartel or anybody else, they would have said the same thing too, because they want to see if probably the court might look into that as a
True.
a factor to determine if it's all right throughout the thing. So I just that's on me there with the whole context of the reasoning there. You see me?
Yeah, I mean, I'm gonna sit and say, yo, them argument, this and that, and try to, fix all sort of, me not go do that. The reason why, because the law work, illegal work. The things them where them are do, we don't know what them game plan, we don't know, so we can't just judge them at face value. You understand what I mean? I say, yeah, we know them are chew a whole bunch of stuff out there hoping to something I go stick. But
Right.
listen, in a court, anything valid, bro. You don't even know. You can't show any argument, you don't know where it may lead to. You know what I mean? So you
Yeah.
can't really say, boy, them lie and know what them are doing. They all know what they're doing.
Kashi, first of all, I wasn't saying that, That's the first thing. And the second thing is this, right, Kashi? It's not surface, If you think about it, right? Even though Cartel saying those things and saying that, oh, I can't take care of my 17 dependents, if I get retried, blah, blah, blah. This is the point. If they find that you are charged and they find that you need to serve the time, right? That is a part of your punishment. It just happens when you serve time. When you serve time, your dependents going to suffer. You're not going to be able to provide as much. You're not going to be able to see your family as much. That is like somebody saying, "Oh, you know what? You can't really lock me up because my mother's sick or my father's sick." It is a part of the punishment. Being away and not being able to provide is a part of the punishment. So if they find that he needs to be punished, it's just a part of it. So it's not a service thing. But at the same time, I understand what you're saying, and I agree with Imhotep. If I was in that position, I would say that too. But I would draw for that card if I had nothing more substantive. If I had something else that was heavier, like my medical records, that is what I would be harping on right now. You see what I'm saying? So it's not a necessarily surface thing. It's just a matter of cause and effect. That's all I have
But
to say.
me understand
Hold
what you
on.
say fully, but
Yeah.
remember it's a retrial. Them a argue still. See, this is not like a initial. This is a retrial. This is
All right.
doing it all over again still. Remember that part there.
Yeah,
You know
All
what I
but
right.
mean?
this
Yeah.
yeah, but it don't matter though, because this is the thing. It is not against listen, if them said to you, say, we have the case to retry you, right? And we are able to, you remember, say it's just like a brand new case, even though it's called a retrial, it's like basically them doing it all over again. So basically he's saying you cannot try me because of the fact that this is going to take me away from providing for my 17 ones. You understand? And it's a fresh new case, right? So that is not an argument that you should grab for if you have more substantial arguments. That's
All
all.
right.
That's
So
all I'm saying.
all right. So hold on, Miss Julia, because
Yeah.
I think
Yeah.
that hold on, the true tell, yeah, you have to allow me to add it to the stage, All right. So just check back in true tell. You cut out yourself. Miss Julia, at this point
Yeah.
in time, where is the hearing,
Yeah.
right?
Yeah.
I think now would be the time for empty the clip, right?
Yes.
Everything out there and
Yes.
see what will stick and what will not. So
Exactly.
yeah,
Yeah.
so at the end of the day, Imago put whatever him can and them see where them are gonna accept and whatnot. But
I agree with that.
go ahead and land, and then Kashi can respond.
And Kashi, big up yourself, and I appreciate
Yeah,
your
man,
thoughts.
up, man. Just
Definitely,
cool, man. We're
definitely. Big
good,
up
man.
yourself. All right, later.
But
Yeah,
just
man.
glad I know me there, you know, in a court to argue them thing there, you know.
Right, but the thing is now that the lawyer saying that you know they have to get a a fair hearing and in a reasonable time. You know, based on the observation, I don't think it's an unreasonable time though. You get what me I say?
But
Yeah.
remember, Buchanan came on TV and applauded the court for the speediness of which this is moving, you know, compared to other cases. You know. He came and said, yo, I appreciate how fast they're moving on this particular case now, because when they were waiting for the letter from the king and whatever, and the timing and whatever, he came and said that out of mouth. Buchanan came and said, yo, he appreciate the speediness of which they're moving within the case. So how the other lawyer now come say that? So that show that they're not even on the same page.
Right, and that is actually an excellent point, you know. People, please remember you can hit that like button. 502 persons are here in the building. You know, you can hit that like button, you can share, you can subscribe, you can hit that link and check in on the panel and share your perspective. If you're a Gaza supporter, you know, anyone at all, you can feel free to engage. I don't want anyone to feel as if, you know, they are not welcome over here. So yeah, man, big up to all the ones and ones, manners and respect. So you know the thing go. All right, so Subi Cheki, let me hear him say the quick and fast.
Yes, family.
Yeah, man, big up. Where you going?
Yellow sober.
Yeah, man. I'm listening, you know. But for me, I get so far from even with that reason about last night, based on the preliminary, I think the judge, I just said, so right now, time no phone really do or not do. So it is clear. Instruction from the judge say, yo, there's no, I never. I'm kind of pick up still. Like whether we're not presenting or present it right now. The argument about the evidence. How I never get to hear how they are them reason for that still, but how is that gonna play out if that evidence is no longer available?
Yeah. And as we have said, a JS1 the Subi, I think, you know, the defense would have been banking on that as a very significant piece to you know, validate their argument. You know, we say, all right, hold on. So one second, Subi. Let me mute in a second here, because your background very noisy. And then you can just unmute when I respond. I'm saying the JS1 is the phone analysis by the forensic expert, which, according to the defense, they are saying that it proves that the phone was tampered with, and you know how the law works. Once the phone was tampered with, it should not be accepted as admissible. You know, so they wanted that to be accepted to throw it out. But what they're saying is that it only have a 1 year lifespan based on the law. So they are not able to use that JS1. You know, you get what I say. But
when you say a 1 year lifespan though, when you say a 1 year lifespan, right? What it means?
Right.
What it means? Like after 1 year, it's decayed. After 1 year, it's no longer good.
All right. So what's this now? They are saying that, right? The JS1, right? The JS1, it and the information, because the JS1 are the phone info, right? And remember, so the phone info is based on what was acquired from the telecommunications company, them, right? The service provider. And by law, it has a 1 year lifespan. So so the defense now, they are saying it's no longer available to them.
Now, what may I say to you? What may I ask is the data no longer available? Or the means and how they collected it? Because you know, like you can collect a document and it's only valid for a year, but you can go back and
So
ask
what
for.
they're saying is that the data, right, from the telecommunications providers have a 1 year lifespan.
No, but is there a mother? Is there a mother for the data?
I'm sorry?
Is there a mother for the data? Is there an original copy?
No, but
original piece.
no, but member said them gonna have all of that, you know. It's just that what they're saying is that by law, it's a 1 year lifespan it have. So here we go on. It's no longer available for them to use.
Yeah, but can they like was it a situation where they requested the data from the mother? Can they go back to the mother and retrieve the data that they need, whatever they need? Can they request that, or is a situation where whatever data is there, it's no longer of use? You know, like I say, a forensic document is no longer used because it has decayed. What is the issue here with this thing?
All right, so
when you talk about 1 year.
Right. So let me just kind of, you know, try and convey it as best as possible. What the defense is arguing, right? The data from the telecommunications companies have a 1 year lifespan. So right now, as they speak, that data, which is a JS1 material, would no longer be available to them to use. You get what me I say, Subi?
But it might take me understand a Subi I said, I don't understand it either. I don't understand it either, no. Because if I have data on a CD, it's good forever. Unless it's like your driver's license, them say it expire on the 10th,
Exactly.
and it expire, but you still have a license in your hand. But the license expire.
Right.
So that's the only way I can reason it out.
Yeah, but James Bond, the context though is the admissibility of such data as evidence that I really remember it have a time span based on the Data Protection Act and the Telecommunications Act and all those acts. So
what? No, but what we're trying, understand what you're saying. But what we're trying to say, why to disappear? Foof.
No,
No,
it cannot be used because it only has a 1 year span.
Okay, that's what we're saying.
Let me ask a question.
It's just like having one apple, and it might in your fridge for 6 months, and after 6 months it spoil. After the 6 months, yeah man, you can't use it again. They are saying that data, right, it only have a 1 year lifespan and that pass already. And that them argue. So them can't use it again. So that's the reason why they are arguing that point. Go ahead, Subi.
I'm not sure if that's the case, though, but I think that's why the judge say, you know what, present that argument and we'll get back to that, I guess, when I'm dealing with it or whatever. But what I'm saying to you is, you know, if that were the case, that means, say, if evidence is on a phone, or data is at a telecommunication network, and it's 1 year after they find this data. Let's say me use my phone to record record me or somebody doing something illegal. You're saying if they find the phone after 1 year, the data no good. That's what I'm hearing from you. Am I right?
That's what the defense is arguing. But guess what going now? You know, say Miss McDonald, you know, Miss McDonald made a very key statement in response to what the defense said, because Miss McDonald said, right, that the court, you get what I say? She's saying that the court cannot determine admissibility of evidence or weight. That is very interesting. The appellate court. That is a very interesting statement. You don't think so?
Yeah, very. But you know what I find interested is when the judge tell them, say, use the time wisely. I think that's a warning.
Well, I mean, yesterday said school start. So you know, say that have to do with orientation. So today she said, boy, school is over. So you know, say the whole orientation settings done. A business time now. So she tell them, say, use the time wisely, because they are saying that them now go past Friday with this matter. You get what me I say? So even the request, Hannibal, sorry to cut your wisdom, even the request for the various courts to submit documents to show how the various appeal, you know, matters have been addressed, them have to go bring that by before Friday. You get what me I say? Them have to go present that to her before Friday. So yeah, man, she tell them, say, listen me now. Nobody with the skylarking thing, you know, because this thing here, it now go pass on Friday. You get what me I say? But before me give back the mic, Hannibal, yeah, man, big up to all the ones and ones, you know. True tell, I think you were trying to call in, you know, call back in and make we hear what you say, man. Big up the ones and ones, and 537 people there. Just drop a like on the stream, and if you like the platform or rate the platform, you can also subscribe. That's our reason all the time. You know, big up to everyone. You know the thing goes. So go to Hannibal and finish the point.
Hey, so may I say, based on the severity of Vybz Cartel, them life and thing, when I really see the defense are put nothing case forward, when I really think the defense put nothing substantial, we can say, aha, or make it look like, say, boy, them really have a possibility of being released. You know, I mean, it's young still, but so far, me think of a man waiting 11 years to get an opportunity to express say, innocence. Me not really see them a put no evidence forward for anything significant to make to convince anyone that them to release him. So far, I want me see. And even though it's the first day still, second day really. So
Yeah. It's something where at the end of the day we have to really watch and see how it plays out and see what is presented and what is accepted and what arguments. Because remember, you know, this argument is all about retrial or acquittal. You understand what I say? So we have to just watch it and see how it go, and then we can see what go on. But so far, you know, even the Shanstorm argument, the judge did not dismiss it, nor could the prosecution. You get what I say?
listen, if they had dismissed
trial based on where the bloggers them are say.
yeah, but if they had dismissed that part, then that would be a bias both on each side, either way. So that's something they had to consider. So I don't really think much of that. Me just see like yo, me not really think them put me not think them present anything substantial for even swear me if say yo, yeah man, them not really make a case so far to me. Just like what Miss Julia said, it makes sense. Me not really see nothing. Me not see no make sense to me what am I present, my brother. That's the reality.
But remember that so far there's not much for us to comment on though. I remember say it's a 5-day thing. So yes, we can say probably so far. Remember yesterday was more like submissions. So today are the meat of the matter. Tomorrow, you know how that go as well. So I think it's a wait and see approach. You know, we are gonna see how that play out. Big up the poorhouse in the building. Manners and respect me, General. Jeremy and A. Simon. You know, FIFA Dan, big up on yourself, everybody. TG Media, manners and respect, you know, Myrna Douglas, everybody, big up on yourself. All right, so let me just allow Chutel to say a quick thing now. Go ahead, Chutel, let me hear what you have to say.
Yes, good afternoon. I will have to speak very low because my son is sleeping right now, so I was trying to call in earlier. Yeah, as it relates to the phone tampering, that wouldn't be of any help to the defense because the phone was tampered with after the evidence, the voice note was presented to the court. So that wouldn't be of any help, and that would seem as if it would be the defense that tampered with the phone. I'm not saying they did it, but that they are the only one that the tampering could have helped at the time when it got tampered with. So that was what I was trying to explain. And I just want Jamaican people to start reading and stop. They have to think. When they read, they are reading, but they are not comprehending, right? As it relates to the juror that was bribed, it would also indicate that it had connection to the defense, right? So based on the nature of the verdict that he came back with, which was a not guilty verdict, I think they should have pressed him more to find out where the 500,000 was coming from and who persuaded him to come back with a not guilty verdict. So that has no case for me. I don't know why this thing's still going on, and I don't know why people are not understanding what is going on. But I think the narrative is already being set, and nobody don't want to read and understand what really happened. So that is my few argument.
Right, all right. So you see, as it relates to that jury thing, them in general, yeah, at the end of the day, is where we can prove in the courts, right?
Yes.
About that jury, right? Good. So I am saying, while the argument is plausible to say that the actions of that tainted juror was to benefit the defense, you know, that will have to be proven in the court and not just a hypothetical thing. Because at the end of the day, my general, you have to can prove it. Now, this man was charged and convicted and whatever. Why wasn't there any information from the investigators to prove that it was the defendants who were guilty of doing this.
And that's where the corruption lie. Because if that guy was charged and then pressed to find out, he was pressed to find out. I am telling you this.
Yeah, your
I am
background.
telling you this.
Your
The
background.
defense would be in bigger trouble than they are in right now. So when they are saying that the system fighting this man, the system not fighting this man. The system actually help this man
Are you hearing me?
in a more ways than one.
Chutel, are you hearing me?
Yeah, me I hear now.
I'm saying your background is a little bit noisy. I don't know if you can probably go around like a quiet area. So at least you man, the audience, with the audience, please.
Yeah, you hear me better now?
Yeah, man, go ahead.
Yes, I am saying that. Even though it cannot be proven, that was the corruption that happened in the trial, you know. That was the corruption. But if it was pressed, I am telling you that the defense would be in problem, because I'm sure that it would point right back to the defense, and we would never reason to go to the Privy Council to waste taxpayers' money, right? So that was the corruption, and the corruption was to help the defense.
So
that is as clear as night. That's there.
Right. So you're saying that with that juror, right, and the inability of the police to reveal during their investigation that the defendants were responsible. You're saying there is corruption there on law enforcement?
I am saying that to reveal the party that the bribe came from, not the defendant, but in all of my knowledge, it is spiked into the defendant. So that is where it lies to me. If they pressed him and continue press him, and they would eventually get the information. Because there's no way, it doesn't make any sense that the court, the prosecution would have paid him to bring back a not guilty verdict. Would that make any sense to you?
All right, as me say again, you know,
I am asking you a question, sir.
You asked me the question.
I am asking you a question.
Allow me to respond. I'm going to respond to you. I am saying your argument is a plausible one. I am not challenging it. But when it comes on to law, it's what can be proven and not what me think. So there's a difference. As Jamaicans would say, it's not where you know, is where you can prove. You get what me I say, me general? So me I approach this matter in terms of what can be proven. So people will say, you know, say the man will try bribe the people, he was acting on behalf of the defense. Yes, it can be plausible, but prove it. If you can't prove it, then leave it there. So, because the reality is that it should be proven that it was the defendants who did it in terms of you know, getting involved in it. Prove it. If you can't prove it, then it make no sense. We try to say I must them, because if we can't go to court.
No, but what I am saying that people are running with the narrative that the jury that tampered with was to, it did not affect the defense. It more affect the prosecution. So they are saying that he did not get he got an unfair trial, right? But at the end of the day, it helped him. If he got an unfair trial, it helped the prosecutor, the person on trial, right?
Right. But the thing is this, you know, as I'm saying, you know, what is Tommy General? As me I say, the police had the resources and the capacity to do a thorough investigation to establish, you know, who else was involved with this tainted juror. We have seen nothing else from the police to say it was any of the defendants. As me say, I'm not dismissing the plausibility of your argument. What I am saying, when we are talking about legal arguments on the court, it's really what can be proven.
Facts we have to work with.
Yeah, we have to work with what can be proven, my general. So even though it's plausible, and that's why I'm saying, I dismiss what I say, it's what can be proven. But all on them say, my general. Big up to Jamon for the super chat. Jamon said, truck brought down from 6 a.m. just a rolling. You know, Jamon, where they are reasoning, you know anything going on. Kai Hype, 1 second, James Band. Kai Hype, big up in my general. Manners and respect, you know. BI strong, Fitzroy Reed. You know, all the ones, I'm gonna big up on yourself. Just drop a like on the stream. Remember, you can also hit that StreamYard link at the top and, you know, check in and share your perspective. Go ahead, James Bond.
No, tell me, I tell you, if you check the Observer latest, you know, they must say the judge lash out on the attorney about the time of the appeal court take.
No. I actually brought that one up before, though. You get what I'm saying? Yeah. I did bring up that one. Probably never check in yet. You understand what I say? But yeah, man, we can drop that one.
Yeah, so that killed them argument because I said Buchanan was one who came out and said this was moving a very timely manner.
No, hold on. Is it the Green or the Observer you thought? Because
the Observer just put it out a while ago. Just put it out.
All right, so look at the screen, right? Is this the same kind of argument?
No, man, look at it. Go look at the Observer. Let me read it. Let you hear.
No, it's all right.
Judge lashes attorney in Cartel case for criticism of delay at the appeal court.
And the same thing that on the screen, James Bond. You looking at the screen?
Yeah, the same thing on it. Yeah, I was looking at Observer. Yeah, the same thing.
You look on my screen, me I talk.
Yeah.
Right. So I just said the same thing. All right, no problem. So as we are saying, as things develop, you know, we definitely try to update as best as possible. And we greatly appreciate the engagement from the people in the chat and people who call in on the panel. James Bond, do you want to say anything else? And then we can make Hannibal say a thing. Hold on. You know, I think we are circulating the reasoning.
Yeah, man, go through Hannibal.
Hey, up, James. Yeah, everyone up. May I say, so far, I mean, at the first day still, but I am just saying, based on a man in a prison for 11 years, I think they would have presented a better case so far at this point in the situation. Me think so. That was my thing.
But we have to still proceed with caution. Because remember, we're not getting it word for word, and we're just getting little bits and bytes and pointers, you know. So we don't know the meat of the matter really. So we still have, and there's 2 more days to go. So we still have a kind of reserve judgment until then, you know.
So, I totally agree with that. 1 second, Hannibal. 1 second, please. Poseidon, you know, say my phone, right? My phone accidentally hide my general. So me just unhide you. I apologize for that. Me have the phone in my hand and it's touch on the screen while me there talk and it hide you. So you can just check back in and make me know so you're there. Manners and respect. And 1 second there. 1 second there, please. The free thinker say, yeah, man, respect. 3,000 subscribers. We greatly appreciate the support. We're building the platform step by step, brick by brick. This is a platform where we engage in intelligent conversations and different perspectives, and we kind of reason it out. So we are here to engage, hearing different arguments and different perspectives. All I ask is that we keep it respectful as big people and mature people, and we respectfully disagree. Go ahead. Go ahead, Hannibal.
No, I already saw me. I say no, but as I say,
all right. It was James Bond that was saying something. Oh, go ahead. No, what is it? James Bond that was saying something?
No, I was saying to Hannibal that we still can't make no judgment yet because, as I said, 2 more days left to go, and we're not in there hearing word for word. We're not hearing the bulk of what's taking place. We just hear bits and pieces what the media putting out.
Right.
So we can't say they're not presenting a good argument. Obviously, the media going to put out the part where them think going to catch the most views and click likes. So we still have to wait and see before we pass a judgment on them.
Right. 1 second there. Poseidon, is this a new account or something? I want to go on there, sir, but you never have arranged me, General. No, man, something wrong here, so man. All right, cool. Let's say a word. Yeah, as we assess still, you know, we said it earlier, and we're going to say it again. It's still early days. At the end of the day, you know, 3 days left, and we have to just observe and take it, you know, as it comes. So we have to see what is being argued and how strong.
3 days left or 2 days left, Imhotep?
3 days left. 3 days left. So I'm saying we have to see how things play out. It's a 5-day matter, right? Yeah, it's a 5-day matter. I think a lot of people kind of mix it up to say, because them here June 10 to the 14th, them things are 4 days. It's really 5 days.
Yeah, man, you're right. You're right.
You kind of calculate the things still. But I saw it go. Just there for, you know, yeah, man. But you know what the thing, as we say, we have to just wait and see how things really progress still, because that's right there. You know, it's a step-by-step process. We will be seeing different arguments being presented. You know, the prosecution are going to present them arguments as well. I think the judge made a very interesting statement, right? To say that the appellate court cannot determine admissibility of evidence or weight. You understand what I say? So, you know, I found that to be very interesting. But even though she was speaking in the context of Mr. John Clark rehashing, because remember, you know, when the matter went to the appeal court, right, initially, they wanted to submit that JS1. You get what I'm saying? And the JS1 now is to show that, well, the phone was tampered with and yada, yada. So she was saying that, but John Clark, you are rehashing something and the appeal court cannot determine admissibility of evidence or weight. So I think that's a very interesting thing. Chutel, do you want to say anything further?
Yes, I was saying that about the phone tampering that happened after the voice note was presented. So that wouldn't be of any help to the person standing trial. So it wouldn't be of any help to them. So that even if it could have been presented, it wouldn't be of any help. So that was what I was telling the persons in the chat.
Yeah, but why would you say it wouldn't be of any evidence, any help when that forensic analysis of the phone, based on what the defense was trying to argue, is that it proves that the phone was tampered with?
Yes, the phone was tampered after the fact.
No,
after the voice. After the voice.
Yeah, go ahead.
After the voice notes were played and whatever, that's you see the first trial. When he got convicted. Listen.
Let him finish, please.
No, I help him out. Let me try to help him explain what I'm saying.
Listen.
Make him finish.
Listen. You see the first when he just got convicted, the phone was not tampered with yet, you know. Is when it is on the appeal, they realized that the phone was tampered with. So it happened after the first trial. And then the appeal again was based on the tampering, which happened after the sentencing, after the conviction. So it obviously somebody from the defense team get some police or something to go mess with the phone to have a ground to stand up on. But that's why the Privy Council never threw it out on that case. Them look past that don't make no sense. Them just threw it out on the Jura case.
So not throw it
out. Send it to retry.
So Carla, let me ask you this question. So what you're saying then, after the detective them obtain the evidence after the phone, that's when the phone get tampered with?
Yes. Yes, that's what happened after the conviction. Remember, in the first trial, you know, when this go on, 1920, you know. So when the first trial happened, there was no tampering. The only thing them did a complain about, said them breach of rights to go in at them phone. That a breach of rights, right? But them still never have no foot to stand up on. That's why the evidence is used, right? Because them say it shouldn't happen that way. Them shouldn't breach them rights to go in at them private matters. Because phone that be a private thing, but they never have no foot to stand up on with that. And then after that, after the conviction, remember in the appeal of Jamaica, you know. So after the appeal, then come up with this ground, say the phone used that when the man them don't get convicted already in a lockup. You get me, I say? Then the phone used. So
stick up in truth, Wilton, not to cut your wisdom. I give you back the mic, right? Anthony Johnson, Friday is the 14th. Fly Eye, shame on you for running with that. You get what me? I say Thursday the 13th, but anyways, a human nature. But my point is though, time will tell. And you know, I'm gonna give you back the mic. You are saying that the phone was tampered with after. Remember that it was proven that the phone was used to send out text messages, right? The chain of custody was compromised. The defense was arguing that even at the initial trial, what the judge ruled was that the information obtained through the phone does validate he was saying the ends are the means justify the ends. In other words, while it might be argued that the chain of custody was compromised, the phone was compromised because it was used to send out texts and whatever. The information gathered from the phone was beneficial to the trial. So therefore, he was going to let that stand. So we can't argue and say that it was after. Because remember, the chain of custody, that is a problem. The phone being used to send texts, that was also proven. That's a problem. So the phone was compromised before and not after.
So
before the conviction, yes, sir. Before the conviction, the phone the compromise.
Yeah, man.
Yes,
the phone.
yes.
No, me I go check back one. Me I go come off of this and come check back on that because me I go.
No, man. Listen. Hey, Carla.
No, me not have to talk no more. It don't make no sense. Me go forward with the argument here. Me I go check on it and come back.
No, Carla. Listen. From the preliminary, yeah. From when them have the first preliminary interviews of bringing the case together, the phone was tampered with. But the evidence was already. Listen, yes, man. Listen.
Tell. Allow him to finish, and then I'll allow you to respond. That's fine.
So listen. When the detective present the case to the head detective, and when the head detective go to the court, and when the head detective forget the file and say him leave the file in him locker, and then the detective present a file, a copy of the file, and say here's the file. That's when the phone get tampered with during that time. The investigation already was concluded and set to us to go into trial when the phone was tampered with. But to say the phone was tampered with after the conviction, the phone was tampered with in early on in an investigation. However, the evidence was already obtained from the phone when the phone was tampered with.
Right.
All right, so let's agree to disagree then. Say what you are saying is right then. Then that means, and you are explaining that the phone was tampered after the evidence was given to the relevant authorities. So that wouldn't mean say them are the reason why the phone was tampered. The evidence wasn't tampered with. The phone was tampered with.
No, but hold on, Hannibal. Remember, we are talking about law and not our personal opinion. You see, in law,
but it's not my personal opinion.
Hold on, I'm not saying you. Just listen to our reason. So I'm speaking in general. I'm not referring to you in particular. In the context of the cell phone, one, the chain of custody was compromised. That is a problem in our court of law. Two, the phone was used to text even before the trial started. Wrong, am I right, Hannibal?
Yeah, because it happened in the early part of the investigation, before the trial started.
So by virtue of that, my general, the cell phone in the eyes of the law is compromised. What the judge in the matter ruled was that the evidence gathered from the phone, even how it was obtained was actually in breach of the Data Protection Act at the time, so to speak. You get what I'm saying? They were arguing that. So I am saying, my general, the phone, one, the chain of custody was compromised. Two, the phone was used, not by Vybz Cartel. It was used while it was in custody of investigators. That is the next problem. So that is just where the substance of the argument will be, to argue in favor of the phone being compromised. It was before the trial even started and them things there. So I just want to say that just for clarity. But
yeah, and Imhotep, and with all due respect, still, with all due respect, the phone was used before the trial, and yes, the phone was used during the investigation was going on. But the only person to be benefit from the phone being used was Vybz Cartel.
All right. That me say too.
You understand?
And the next thing, why didn't
hold on there. Using that argument is the same as using the argument about the tainted juror. At the
Right.
end of the day,
So hold on,
Hannibal, man. While that might be plausible, at the end of the day, my general, the law are the law. You get what I say?
And I totally agree with you. I'm not listen, that part of it, I'm not fighting against that part. But what I'm saying is like this, yeah. The same way how we have a conscience and can see, say, are them the person that will benefit. The people who are handling the case is looking at it the same way. And those are the same reason. Those are the same reason why it is what it is now today, because people are knowing, like, listen to me. This man are trying to pervert justice, you know. And if this man is trying to pervert justice, then we gonna fight him differently to make sure the justice is being served. Not saying that is the case, you know. I'm just saying that is just a plausibility of how people are think. If that make any sense.
Right, but at the end of the day, too, they cannot use a plausibility to argue a legal point.
Facts.
There's a lot of things they cannot do. There's a lot of things they cannot do and should not do, but they will do it, though.
No, but hold on. Yeah, but I understand. But what I'm saying is in general, right? Even though people might say, you know, say that chain of custody thing there that was beneficial to the defense, and you know, say the text message where the man them are sending off of the phone that was beneficial to the defense. The reality of things is that the phone was in the custody of law enforcement, who we expect to deal with the thing the right way. It was not in the custody of the defendants. So therefore, whoever want to follow up the thing, right? Yeah, we can assume this and assume that. But if we can prove it, then it's not where we know, it's where we can prove.
Well, you're right. But
so let me ask you this question. Yeah. So hear this, yeah. So no, his attorney now is trying to enter that into evidence. No, and the judge is saying, nah, that's not what it's about right now. So what's gonna happen now? Is that part gonna be in the case if it should go to trial?
Well, what, the JS one?
Yeah.
You know, as I said before, as I read before, the attorney was arguing about the 1 year time span that has passed, and they won't be able to use it. That was what he was arguing. But the court is arguing that they are not here to determine if it's admissible or if it have weight. So me still I watch and see where the court are gonna say about that. Because remember, you know, this matter will only be relevant if there's a retrial, right?
And the next point, what do you say about the witness, the star witness? That how them are gonna break that now? Cause it seems like we are come up with ways now for how we can break this case. So make I hear your talk on that here. What you have to say about that? What is your opinion on that? Or they are going to break through what the star witness said. What is your opinion on that?
You mean what the star witness said? But remember again, general, see, this argument is a bit subjective and not absolute, because here and now, you see that star witness conversation is only applicable to a retrial, not true?
Yeah, but I know, but if there's a retrial then. But we are not dancing around anything. We just a talk now. We are reasoning like what you say. So if there's a retrial, how do you explain? How would they explain away the witness? Them can say the phone tamper with the jury did this and the which in my knowledge I might not be the.
You ask the question, hold on them. I give back the mic quick and fast, because here we go now. You know, say me not really like, from my perspective, I don't like to comment on the hypotheticals of to say what is or what if, because especially if something will unfold in front of our eyes, I am willing to wait and see how far they work out. But if you want to add an argument based on that question, I am okay with hearing what you have to say.
Well, I am not adding anything. I don't have anything to add as it relates to that, because the only thing I could add as it relates to that is that there's an eyewitness. He was there and he told the court everything. At first, they said he was the defense said he was pressured, and the man come and take the stand say he wasn't pressured, and the man talking in details and everything much based on my understanding. You get me? I said the dog bite, everything, the doctor thing, everything, cause based on what I'm saying, him did I say at one point and Cartel never did want to hurt him. I just lizard alone and the next brother there when him Rajic him did want to hurt the two of them, right? And then him them reason it out and whatsoever and the dog involved and then this man must jump the fence and whatsoever. And this everything unfold. You get me? I say so based, but me not going to the whole of that. But based on that, you could see him say, "Oh, that is a strong." I know just the voice note and the phone and that alone, you know, them are record, you know. And even the video to was sent out, you know, where the man I say, "Oh, what we do? Use the picker, swing it, or use a knife," and the man actually have vlogged the thing, you know. And me I wonder how most Jamaicans come up with these things that the man innocent. Me don't know how.
Emotep.
You can't understand it.
Emotep.
Hold on, General. Hold on there. Just remember, people are gonna have them perspectives. I remember, so we are not here to superimpose our ideas or what we think on others. So while we understand, I say, how people formulate the idea there after so much, at the end of the day, it is what it is. 1 second. Moderators, anybody that types in the chat no Vybz cartoon nonsense, please delete it. We're not over here to disrespect no Vybz Cartel or disrespect anybody. Uno keep that over wherever uno are and stay in the bushes. I don't want anybody over here typing no nonsense about no Vybz cartoon. Right? Uno hear vloggers say this nonsense, I want just regurgitate it. Yeah, over here, so we don't do that. Over here, all we say is that uno free if you say what you want to say, but keep it respectfully. But uno not going to come over here and type nothing but a Vybz cartoon nonsense. So just moderators, just make sure so delete that nonsense, please and thanks. All right, 1 second. The black light, big up yourself, you know. I'm manners and respect. Big up to
me I leave you still, you know.
all right, hold on, man. You know have to run going away, man. Hold on, man. Give me a second, man. And you can do a formal exit, all right? So 1 second. Big up to the ones who check in. For those who are new to the panel, the platform, and you might want to join the panel, you can hit that StreamYard link at the top and you can share your perspective like all of us up here. All right, so Kashi, 1 second. Since Truth tells him I'm gonna leave, let me just make him do a formal exit there. So go ahead, Truth.
Yes, so enough respect for allowing me to share my views, and we'll see how it play out as it relates to the rest of the hearing. And I hope that justice is served, because this will definitely go down in history. If it go the way that if this man come off, me think say it will go down in history, and there are so much things me feel like say this is not about him, you know. No matter who the day in the position when they with this amount of evidence and this amount of thing, anybody with the day in the position here and get off, it have a lot to say on the justice system, yeah. Whole heap. So that's my few sense. So enough respect and blessing.
Yeah, man. Man has a respect, man. All right. So maybe make Kashi say a thing. Unmute the mic, Kashi, and got you.
Yo, honestly, me just did forward back to try find out what we did discuss today. I understand me. I say, what's the topic? What we are discussing? We are discussing the hearing, or we are trying the man them, or we just want to focus, Bridget, and not go all over. Let's just focus on the hearing. You know what I mean? Because that was winded a while ago. Because me understand and I try to explain a thing, and it was just going around and around in circles. And
yeah, because
you know, we just focus on the reasoning, bro.
One second, Kashi, me don't tell the general say here we go on. Me now get ahead of myself and deal with the whataboutism and the hypotheticals and say if it got to a trial and whatever, right? Now, me don't tell the man say me I wait and see what the court say. However, you know how the thing go, we allow people to express themselves. We not have to agree with it. So the general, they just want to get it off of him chest. He say him 2 cents, and the man just said as you know, evidence is there for this and that. And as me I say, all of what him say is only applicable in the context of a retrial. But as me say, me just make him say what him say in closing. But me like to kind of stay in at the present moment, and me no want to put the cart in front of the ass, and me just wait and see what go on. Wife, it's God bless, big up. Mood man, big up yourself. Yeah, man. So go ahead, Kashi, and finish your point.
No, man, I hit that, man. I that me there, say, you know?
All right. No, don't say a word. G, yeah, unmute your mic. Let me hear where I said it.
You know, so the call, I'm the one say I think to before him jump off. But yeah, you have to remember call, you know. So you have to talk about the star witness. Now. Remember, so the appellate court have the star witness as a liar. You have to remember that part there.
Right.
If you read the transcript, the appellate court has him as a liar.
Right.
Good.
So, I mean, he was, just to use legal term, not credible, not true.
Not credible.
Right. But go ahead and make a point still, because a valid argument.
No, I just that me the one point out to the boss before him jump off.
Right. All right. I mean, that's a great argument too, as a pushback to what he said. And as we said earlier, that argument about the validity of a crown witness is only applicable to a retrial, and we don't know what's gonna happen come Friday. You get what me I say? All right, that's how we did.
Exactly.
All right. So, do you want to say anything further, my general?
No, I'm gonna go and listen.
All right. No, sir, word, man. Manners and respect we check in same way. You see it? All right. So, I don't know if Kashi wants to say a thing or Hannibal wants to say a thing, you know. They make me know, you know. Because you know the thing going on, a reasoning I go on same way. But all I'm saying is that, people, I am willing to wait and see how this thing plays out, right? I am not here to cast any judgment. I'm not here to be premature, right, in my judgment on this matter. It's really something that I am willing to wait and see how it play out. And then we definitely can say, all right, this our go on and that our go on. You understand me? I say I just write this so me kind of there on this matter, because I honestly think that both the defense and the prosecution will have, you know, valid arguments, you know, for or against. Remember, the prosecution has to argue to say, well, here we go on. This trial settings here, you know, say the reality is, yeah, man, it should go ahead because of such and such. And the defense has to argue that as to why there should be an acquittal. So it's the better argument that's going to stand up. And I write this over there. Big up to Jaim, you know, yeah, man, all the ones and ones them. Big up all the ones and ones them for the check-in. Mood, man, yeah, man, respect for the super chat, my general, greatly appreciated. FIFA Dan, you know the thing, go. Big up yourself. All the ones and ones them who check in, wanna big up on yourself as always. So as me I said, you know, it's not about you know, a retrial settings, because we don't know what's gonna happen. What we have seen so far is that there are some submissions that were accepted by the court, and there were some admissions that the DPP say, no, man, throw out this man. Vybz Cartel son saying that, you know, his father's health cannot stand a with trial. Yeah, man, he's not a doctor. So at the end of the day, his statement has no merit. You know, that's how the DPP has said, throw out that one there, my lord. And the court has said, really and truly, you know, this requires some doctor to really make these statements in terms of an affidavit. So we there I watch and we see what go on. It's a lot that's gonna unfold. It's still early days. There's a lot that is gonna be unfolding as time progresses. And I think we really just have to just go and observe what go on in them. Something they get with me. I say, Kashi, do you want to say a thing?
No, you know, really, may I pay attention to this thing here. This here. Oh no, me on it. Hold on, me a second. Yeah, may I pay attention to this thing here because, you know, me really want to see the justice system work the right way. Whether a man guilty or innocent, I want to see them do it the right way. That's what me they here for. Because anybody could be in the defendant's shoes. You understand what I mean? I say anybody. What if you were in that position? What would you want to happen for you? You understand? So regardless of biases, if you think a man do it or not, you want to see them prove it beyond a reasonable doubt. You understand? That me I look for.
Right.
And we're not there trial yet, so me don't want nobody think me I jump the gun even though you hear me say that. You understand what I mean? I say may the best argument win.
Right. And Blacklight, call in, you know. Call in Blacklight and tell us why retrial is a must, because me certain say, right, all the way I say our feelings you talk from, because you can't talk in an absolute. You cannot say for an absolute fact today, Tuesday, June 11 at 3:49 p.m. that retrial is a must. You know how we reason over yourself. So that's a subjective argument. However, me not dismiss you. So hit that link, call in Blacklight, and tell us how is retrial a must. Me really want to kind of understand what you mean by that, because you are speaking in absolute, and it has to be a subjective argument. So all right, there's something there with that. But I agree with you, Kashi. It is something we have to just observe and see how it play out. Big up Cindy Campbell says, sending love and respect, Free Vybz Cartel. The reality, people, there are going to be Gaza fans who are supporting their artists. So whether we like it or not, people are going to support their artists and they are going to say Free Vybz Cartel. You get what I'm saying? So for Justice League people and other ones who are so emotionally invested, to try to counter these people who are fans of the artists, then I just reasoning. You have for and against. And I am not here to tell anyone say you have to say A or you have to say a B. You will have opposing sides. People are going to say Free Vybz Cartel, and some people are going to say Warm to Lizard and him family and whatever. So I just decide there. All right, Blacklight check in now. So that absolute statement the way you make, is it a subjective one or an absolute one?
I might guess that as far.
All right, thank you for the clarification, but go ahead.
Yeah, I might guess that as far as we concerned, because I don't see what would have changed, because there is a technicality that throughout the results of the last two hearings, because regardless of people calling in talking about what the Court of Appeal found from what they didn't find, I'm sure that the Court of Appeal approved the first sessions, the first trials results. Isn't that right?
No,
Our
I'm
Court
sorry.
of Appeal
I'm sorry,
our Supreme Court decision. Don't it? That's why the appeal went to the Privy Council. If our Court of Appeal didn't approve of our Supreme Court's decision, matter wouldn't reach to the Privy Council.
Right, so because the appeal court did pave the way for the matter to go to the Privy Council, right?
That's their natural duty in the course of things, but they approved of the ruling. That's the point. So nobody can call in and talk about the Court of Appeal's position without discussing the fact that they approved the first judgment.
Yes, but and they were proven to be what? They have expanded them face based on the Privy Council ruling, right?
Based on a technicality, I wouldn't say that's an egg on the face.
No, that is egg on the face because the Privy Council rule against them. So no matter if a technicality or not. 1 second, Blacklight. Big up to Malidan TV, Manners and respect me, General. Greatly appreciate the support. Yeah, man. Big up the Vendetta, General. Hold on the Malidan. Let me see what I go on to. Yeah, man. You know what the thing go. Manners and respect. Big up the sister from St. Kitts. Big up the ones and wherever you are from checking in. You know how the thing go. All right, so yes, Blacklight is a technicality, fine, but there is still eggs on their faces because they agreed that there wasn't a tainted juror, and the Privy Council say yes, there is. So go ahead.
All right, my point to you is that I would believe that the Supreme Court judges and the Court of Appeal judges would love to see our courts get it right, bar none that technicality. So you see, just the fact that you perceive it to be egg on the face, I would perceive it from my personality, if I was involved personally, it would be a point to prove to the Lords, So I would believe that a retrial is where most of the legal fraternity is looking forward to, from our angle, especially.
All right. Yes. Go ahead, Blacklight.
Yeah, especially those that are perturbed by the smear campaign of the interpretation of the Privy Council's judgment. So, from that aspect, people with a legal interest would be much more interested in a retrial. Whoever win, but that's my take on it. A retrial is a must.
All right. So, and again, I'm happy you said that. I just your speculative guess that and things like that. So it's not absolute. But when I say eggs on the face is still in a Blacklight. May I ask you the question and give you back the mic?
Mm-hmm.
Weren't there previous precedents in Jamaica? the Michael Manley versus Jamaica Gleaner, wasn't that a precedent that the court should have acknowledged?
Yes, Imhotep.
Well, Blacklight now answer me.
To be fair, to be
Yeah.
fair, brother, I can't speak on that without reading that case properly.
Oh, Blacklight. Hold on, Blacklight. Come on,
I
man.
never did. I only can tell you what the commentators have said about their conclusion and interpretation of it. And here the point now, is that no side of the both parties that were involved in the matter raised any precedents.
No, I get that, but hold on, no, man. Me not talk about both parties.
Even the Privy Council.
Hold on, no, but Privy Council are England, so me understand. Said them are asked. Remember,
It don't matter. Any one of our reported cases could have been used.
Don't say it don't matter, because remember the Privy Council was asking, at the hearing if there were any precedents, and I think Isaac was going to Australia and Canada. No one went to Jamaica. My point is, I am saying egg is on the face, respectfully. I'm not use it for bash the justice system. I am saying egg is on the face of the appeal court.
I don't agree with that. If the gentlemen were
argument point first, and then you can rebut. I'm saying there was a precedent, and that's why PJ came out along with you small, or you small came out and they said what they said. As brilliant erudite legal minds, they said that, watch this now. How did they miss that precedent with Mike and Manley and the Jamaica Gleaner that occurred in the 1980s? Right? So by virtue of that precedent, had the appeal court use that precedent, then more than likely their judgment would have been what? Yeah, man, say uno have to go retry this or whatever. So I don't want you to dismiss that precedent, because
I don't want to speak on a position in terms of my brother. It's a people interpret. It's a law is not absolute as what you admitted that. So you see a man looking at a precedent and reading it here now. I might look at it and read, and I distinguish it from the case that we're dealing with at hand. While he reads it and it collaborates his position. While I read it and I find some points in it that distinguish it, and it's between the judge to look at the precedents and say which one of us have the stronger arguments that will apply. Either we distinguish it here from the matter here, or we use it as the precedents to support the decision or to guide us to making the decision for the matter here. So I can't just tell you without looking at the case, my brother, because some commentators, even though they are scholars and they are erudite minds, I cannot just tell you straight off the bat because those two gentlemen said so. That is a set precedence that should be applied to this matter. I would have to definitely read it, and then I can say I agree with their comments, and I can see that position would possibly be the favorable position if it was brought before the courts.
Right.
But as far as I'm concerned, it's just a hypothetical argument from here on right now until it brought before the court or the Court of Appeal address it, or if it goes to a retrial, or if any other discussions is brought up in this session for the determination of a retrial or not.
Right. And Joe, big up Joe. You make a very valid point, Joe, when you say it's the defense that the burden of putting that argument forward.
Of course.
Precedents with Michael Manley.
Of course.
I agree with that. So even when the Privy Council was asking if there's any precedents in Jamaica, the defense should have known that. But what that exposed, Blacklight, the elephant in the room is that this now, our justice system is outdated in terms of updating from manual to electronic, because what we put them case there in some little room where people can't take up.
A lot of those cases are unreported, and they're not even academic writings on it. So the profession itself, all of these learned attorneys that are scholars here and King's counsels and all of that, they're not writing journals. They have a legal academy that is studying cases, putting forward positions, and discussing matters of academic legal importance for the public to be aware of. So that is the point, We're trying to step away from the Privy Council, and we have a common law structured legal system that depend upon law and precedents. And we have a lot of our cases unreported without writing journals on them. We don't have a proper academia set up around the legal system, which is what is going to inform us of precedents and update precedents and that kind of a thing. If we don't have that in place, then we don't really serious about having our own justice system and final appellate court, you know. Unless we go and change to some kind of coded system.
Right. And as I was saying, right, you see the fact that we are not updating these manual, right, precedents into the electronic system. A lot of these things are sitting in some shelves, cobweb full up, but at the same time, right, they could have used it. You get what I'm saying?
Emo, let me tell you this, Emo. There are cases right now that are going on in court right now where the files are lost. So I'm trying to say to you that there are a lot of cases where even the precedents are not reported and cannot be found. Is what I'm trying to say to you. See,
right.
we don't have a proper system.
Right. Yes.
We don't take it serious. We're not people that take law and order serious.
Right. Big up the mood man for the super chat, you know. Mood
And
man
that is
said,
the kind of confusion that we have in society when people have disputes. Obviously, from the smallest areas to the society to the largest areas in the society, apparently the only way that they resolve disputes is not in courts. It's on the streets.
Right. Right. Big up the mood man for the super chat, you know. Mood man said, free up the Gaza boss. Yeah, man. Manners and respect for the you know, super chat me general. No, I agree with the black light. Oh, go ahead.
I'm gonna leave here, my brother.
Yeah, man. Manners and respect, man, for your take still. But Blacklight, yeah, man. Go and check out that argument by PG and U Small still. You get what I say?
Yeah, I'm gonna see if I can find them a deal with and if we can find the case any at all.
Right. Yeah, because that was Michael Manley versus the Jamaica Gleaner. I think that was 1983. Don't hold my feet to the fire, but it was in the 80s. Michael Manley versus the Gleaner. There was a member of the jury who was also a part of the workers' union. You get what I say? And by virtue of him being a member of the industrial workers' union or something like that, he would have been like a conflict of interest. And as such, the judge actually removed him and disband the whole thing. You get what I say? So that actually occurred. However, I remember in a Blacklight at that time, right, there was still the provision that would allow that person to sit on the panel, right? And as long as not being dismissed by the judge, they are good to go. But that judge said, here we go on. I smell conflict of interest. Let us dismiss this juror and thus dismiss the whole thing and start all over again. So that was a great legal precedence presented by PG and U Small, and they are baffled as to why no one actually brought it to the fore.
That's a civil matter, don't?
I'm sorry?
That's a civil matter, don't?
Yeah, man. Yeah. But we're talking about legal precedence, though, in terms of a jury, the context of a jury. So no matter if a civil or you know.
No, brother, you can't say that, man.
No, but hold on, man.
Don't assume that.
No, in the context of the Jury Act, that's where the argument is. Where there is a conflict of interest or a tainted juror, right? Yeah, man. That they not talk about, man. That man who was a part of the trade union, he was considered to be tainted because of conflict of interest. So what the judge did was to dismiss him and just dismiss the whole jury and start over again. So the context of the argument is really about a juror being compromised. You get what I say? So we do it was a civil matter between Michael Manley and the Gleaner. It was all about a juror being compromised or a compromised jury. Go ahead.
Could they have continued, or they didn't have that option on the table as well?
No, they could have continued, but the judge chose not to.
All right.
Yeah, man, no problem, man. You know what thing, man. We there on them thing that we can always reason about it still. But I am saying the problem with that is Blacklight. It does highlight the fact that our justice system is very slow in updating the records from the manual thing to the electronic. So the government needs to look at that and say, here we go now. You know, these are things they have to work on so that this information is accessible. So ones can Google and find that precedents that occurred in the 1980s. You get what I'm saying? Yeah. All right. This is Myrna Douglas said as yes, the civil case is a precedent re jury. I agree with you, Myrna Douglas. You get what I say? It was all about a jury and quote unquote conflict of interest or a compromised juror, and the judge say, yeah man, get rid of this man, and yeah man, make we just dismiss the whole jury and deal with the thing. So that was a precedent. But again, now it points to our slow nature of updating from the manual things to the electronic. Every other country I try to update them system from the manual cases to have it on the internet or have it electronically. As I said, black light, even these law schools don't even teach these things. So none of these lawyers were graduate from Norman Manley or wherever, then them not even yeah man. But hold on there. Well on there, man. The private figure. Be careful with the wrench, my general. I don't know if a mistake you make, you get what me I say, but yeah man, moderators, let's us make sure that whatever comment we are gonna delete or hide, it's a valid one. All right? Yeah man, please. Yeah, black lights. As me I say, my general, the system, it needs to update, all these manual things, because these things can help. Because I am pretty sure, had they been aware, the defense would have probably presented that. The defense would have loved to have known about that precedent with Mike and Manley and the Gleaner, so they could present it to the appeal court too. You understand what I say?
I would believe so.
Yeah. And I'm just saying, the appeal court now, well, as Joe really said, the burden of proof in presenting that argument is really on the defense, not the appeal court. But the appeal court, probably them never aware of that neither. So them just side with the thing and say, all right, here we go on. Based on the provisions of the 1898 Jury Act, yeah man, this man, as long as the judge don't dismiss him, he is considered quote unquote clean. You understand me? I say, but the Privy Council make them know, say, here we go on. Say this thing is still, yeah man, and I saw it going up. Yeah man, in a real life. You see it?
Boy, I tend to, I am in between where the Privy Council find that to be a problem in terms of, is there an issue with this matter in terms of what the Supreme Court decide to move on with the tainted juror?
Right.
I believe that discretion on the ground is to determine whether or not the entire jury is tainted. I believe that determination is something to be made on the ground at the hearing. I don't believe it's for people a year or 2 years after in the appeal session to be looking at technicalities in the law to say what they believe was happening on the ground 3-4 years ago when the trial was happening. The best person to determine if the entire juror was tainted by the unfortunate situations that happened at the end of the trial, right at the end of the trial, would be that judge that is sitting over the matter. And I believe that is the angle where our Court of Appeal would have looked at it to say, all right, it is within his discretion based on what we see in the position of the law and the precedents that we have before us. So you know what? Who is better than to exercise that discretion than the gentleman that was there, that had discussions with the foreman and the both sides of attorneys? Remember that as well,
Right.
So when I'm looking at the Privy Council, I'm not gonna say they are wrong. Definitely not gonna say they're wrong for finding that position, but I'm gonna say this: they would have been absolutely right to confirm both decisions.
Right. Big up to Alex Smith, Alex Smith, yeah, I agree with you that Jamaica might not be a first world country, but yeah, man, there is the need to update yeah, man, these precedents and these legal judgments as quick as possible, because it is beneficial. So if they need to employ more people who are trained in IT, then employ more people. Provide the funding to employ these people with the responsibility of updating all these old manual court records so that they are accessible, electronically. So I agree with you, Alex Smith. You get what I say? But had this been available or being made aware, maybe the defense could have presented it to the Court of Appeal, and that would have been valid grounds for the Court of Appeal to rule in their favor. So we wouldn't have to go to the Privy Council, where you know how the thing go. One bag of money have to spend to go Privy Council. The average person can afford it, but at the end of the day, people with money were able to go there. So the reality of this matter as well, you know, black light, whether we like it or not, you know, if Vybz Cartel never have the money to go to the Privy Council, you get what I say? It would really show say a man would have really lost in a prison because he couldn't afford to challenge the matter beyond our local appellate court. Because if I did a man like all me, we can afford Privy Council, then you know how that go. My goose cook. So it just goes to show again that you know, had he not have the money, we would not be here talking right now. So that's just the reality of things. We live and we learn, and there's a lot to learn from this matter as well. Irrespective of how it plays out, there's a lot for us to learn from this case. This case is gonna be case law. Yeah, I'm going black light.
Yeah, one last question, my brother. I know this is a bit of a sidetrack, but you see what is happening with the Young Thug issue yesterday?
Yeah, man, I saw where they arrested his attorney. As a matter of fact, his attorney actually asked, watch this now. His attorney asked that he be placed in the same cell as Young Thug so them can work on the case. Isn't that funny? And guess what going on now? Joe Biden's son was found guilty on the firearm thing there too. So him in a trouble, but we know that Joe Biden will pardon him like how them pardon the turkey every Thanksgiving still. Yeah. So that's why I really care about Hunter Biden case. But he was found guilty as well on all 3 counts. But the Young Thug thing, Young Thug thing was very interesting because the lawyer started talk some things and the judge said, where you got this information from? And he plead the 5th. And the judge said, all right.
You know, it's the part where I watch where he got an attorney to come back out. Because, you know, him finished the hearing yesterday and then him arrest him. So apparently, he was able to forget to appoint an attorney. Matter about steal himself, you know. So his attorney came into the court, and then they had a back and forth with the judge. 2 of them, which actually represent like this Gaga car. This is like this community of attorneys are criminal defense lawyers, and is the head. Is the funny part of it now is it's the same Ashley Merchant with the lady we take down the Donald Trump case. We're going to Fannie Willis. She represents Steele now in the contempt case. So she come in and have a quick back and forth with the judge, and she makes some points. So the judge actually confused civil with criminal contempt, and if him don't confuse it, and if him will give him an indefinite sentence, it has to be civil. So and the fact that him call it out and declare it says criminal contempt, that money is due to all the due processes that any accused would be entitled to. And so she bamboozle him, and the judge say, "Yeah, hear me, give me about 5 minutes, and I go back and check my chat GPT-4 and come back."
Right. And the reality is that, you know, he pled the 5th, and the 5th Amendment could not save him. His right to remain silent. It could not save him, but I think the judge was considerate to say, well, he's gonna speak to the sheriff, right? And see how best they can arrange for him to be in the same cell as Young Thug, so them can work on the case until about a week or something like that or whatever. How much?
20
days. See that? Yeah, man. So him and Young Thug can work on the case in there. Alex Smith, the CCJ right now is not the final appellate court. The Privy Council is. The Jamaican Constitution states that any departure from the Privy Council to the CCJ should be done by Parliament. But people are arguing that it should be made in a referendum. And I agree with that too. I think that it should be a referendum because it's a matter of national significance when me not really feel say 63 parliamentarians are the upper and lower house. 63 parliamentarians and probably 15 senators, something like that, whichever way. Must determine if we keep the Privy Council or the CCJ. So as it is right now, Alex Smith, the CCJ is not our final appellate court, and it would take an amendment to the Constitution to do so. And that is where they're going as well, because what is now? For those who are pro Privy Council, the average Joe cannot afford to go to the Privy Council. Miss Shanique Myrie, you know, for ones and ones who remember that case, she was the Jamaican that went to Barbados and them strip her down, treat her like criminal, you know, violate her, strip her down and search all kind of things, all kind of openings where she have. Them search it, say them a look for this and that. And she sue them through the CCJ and won. Now, you know, yeah, man, if it was a Privy Council, our money would have it all. So, again, now, for those who are pro Privy Council, we have to factor in that the Privy Council is not for the average person. The average person cannot afford to go to the Privy Council. You understand what I say? So, I, for one, I agree with Mark Golding. Decolonization, which means step away from the Privy Council. It's a reflection of our colonial past. And I think that as a Caribbean nation, us being CARICOM as well, a Caribbean community, I think we should have that court system. You get what I say?
I don't believe we should just step away without looking at the option of having our own final appellate court, because I believe that CCJ is still inaccessible and is still a competitive grounds for people who, in terms of people who earn enough funds that can afford to have them attorneys fly out and go do matters and that kind of a thing. So even though it may be a little bit cheaper than the Privy Council, it's still not as accessible as a local court would be. Why are people who want to be sovereign and independent don't want to be the rulers of their own destiny as how them courts go interpret the laws that the people them pass, that them vote for? That don't make sense in passing over that and delegating that to other people who don't live here, you know, my brother. May I be honest with you. I'm gonna be honest with you. And at the same time, it's still inaccessible. So it's good and all dandy to say, hey, you know, we don't need the Privy Council, but we don't just run to the CCJ.
All right. So my take is this in a black light. We're looking at our final appellate court being local. That would mean that the appointment of these people will be coming from some degree of political influence. Right?
That is what we need to change as well.
Right. So be it through the House or the Senate, the upper or lower house. You get what I'm saying? With a prime
minister, structure, you know, because we can have a final appellate court where we have elected officials, what the people appoint as the superior, the supreme judge or chief justice or whatever we want to call it, the supervisor or the lord in charge of the rest of political appointees. So we can balance it, you know. We don't have to take away all of their right to efficiently select the most erudite or the most appropriate candidate for the position. Right. But certainly we can have an electionary process in terms of we voting for a chief justice or for who will set the directive or the policy or who have the major final say if there is a equal vote in that on that board on a matter or that kind of a thing. What I really want to get to, you know, what we really need to get to based on where we are and the kind of flaws that we have in our system is that every serious conviction needs to go through at least a judicial review, whether or not automatically. Once it attracts a certain amount of charge or years, once I'm going to sit down for life or 20 odd years or something, his matter right now. I'm not even talking about moving forward alone. I'm talking about right now. All of those matters need to be subject to some proper judicial review. Even if we just remove the Privy Council and we put up our own final appellate court, it don't touch on those matters all now. You understand what I mean? So that is what we need to address. Since we know we have a system that was heavily antiquated, was flawed, not properly addressed our issues on the ground, basically. And so because of that, there's a whole heap of peculiarities and issues that would naturally take place, especially with a not so efficient justice system and a people that not so adept to law and order. See? Yeah, so man, we need to look back over all, because I mean, man in the right now, we have the 20, 30 years, they're probably depend on shaky. It's not probably. I've seen people being let off from death row from the Privy Council appeals, where there was video evidence of the crime itself from start to finish, where none of these appellants were on the video. You understand what I mean? So there is things that we need to go go look through and dig up them files there. See?
Right.
And set up a judicial committee that
Right.
review and determine, say, yo, watch out. This matter you probably can go to our court of appeal, yeah, so for a final hearing, or we do a retrial, or guess what? We throw it away and exonerate this person here and allow them to sue the state if it was shaking nonsense and an obstruction of justice or just rubbish that got them convicted. So I said that to say that we can't just look at, say, we X away from the Privy Council and we solve our judicial woes. We have a whole heap of problem here. We start with not just the Privy Council being the head of the judicial system.
Right. Big up to Clifford Cameron, you know, Jar Eubanks, big up on yourself, you know. Big up to all the ones and ones them. The problem we have though, black light. And this is a matter we have to speak on from time to time. There is no impeachment legislation, right?
Yes.
And this is where the final appellate court being in Jamaica is a problem for me. Because right now as you speak, you know, say you have some PNP where we'll say, boy, Andrew Ownless outstanding for 3 years and whatever, right? And what we are saying is, as it relates to the impeachment legislation, we want to have that in place. But if it's a case where high-profile people are impeached, so for argument's sake, the Prime Minister has been impeached. You get what I say, my general? I am a bit skeptical of our local appellate court handling this matter. Because if you say a CCJ, you know, would display at least the fact that it's not local, yeah, I think it would be better to handle a matter of this nature. So we'll look at it from them angle too. You get me?
Wait, no, I'm gonna push back. I agree with you, to some extent, but the only problem I have with that is that, you see, even the CCJ on its most serious matters that it has ruled on is the most disrespectful in terms of the observation and acceptance of those judgments from its own members. So I'm going to say this to you. If we remember that international appellate courts don't really carry teeth in a sense where we can rule on a matter and a government, I'm going to say them are going to ignore that forever. And there is nothing that the members are going to do, my brother. That is
you know what's funny? You know what's funny? Blacklight, PJ's you know, very excellent speech that he made at UWI last week, right? It's from the 90s. They were talking about the CCJ and whatever. I think even both of them were agreeing to the CCJ. But, you know, we're going to wait and see. But we have a problem with a final appellate court being local. And we have our Prime Minister being impeached. You get what I say? And that going as far as to the local appellate court. Case in point too. The DPP, Paula Llewellyn, right? Right now, you know, they are challenging the ruling by the court to say that her tenure from last year, September, was unconstitutional.
Yeah.
Listen, I am of the view, and I'm not infallible, that the appeal court is going to stand with the previous decision. What they're going to do now is take it to the Privy Council. You get what I'm saying? Now, what is now? If the final appellate court is local and a matter of this nature with the DPP, and it's the government, you know, members of the government through the Attorney General and them people that deal with the matter, you know. If this is to go to the final appellate court, which is local, I find that to be problematic. But again, now, you know, I think it's something that should be studied and looked at, and look at all the pros and cons. I will from this still. But you know, I'm gonna close off now, so let me just say the closing arguments now.
Ready, you want me to go first?
Yeah, man, you can go ahead.
I mean, we touched on the points, and we need to get serious about our own local judiciary reform, and that go for the schools as well. The schools have this policy like it's a closed gate situation, and like you have to come from a certain area of the society for them grant you access to go study law, while a bunch of them little people who come out there need schooling even when them already passed the bar. Is the message? So them definitely need to level the playing ground. At one point we heard that other colleges got the chartered removed that stop the monopoly from having one school where private for have a lock and key over with judiciary system and who will be trained in that profession. But and that I'm not seeing it open up, even though the gate open. I'm not seeing people taking advantage of it. It just seems to be like it's stuck same way, like it's a preserved society and a little club, because that is part of how they hold the people backward, you know.
Right. Yeah, man. Respect as always in a black light. Kashi, you still there, General? Let me see if Kashi still there. Look like Kashi gone. All right, Blacklight, big up yourself, you know. You know, say later, a Rick Storm, you know, Rick Storm, I'll touch out later. So, you know, so we are go over the same way. People, yeah, man, thank you all for supporting the platform. 406 people there. Just drop a like on the stream. Hold on, let me look at the poll results. You know, yeah, man. And remember, if you have not yet liked the stream, you can, you know, drop a like on your way out. So, the poll results, 679 votes. 41% say yes, they trust the justice system. 59% said no, they do not trust the justice system as it relates to a fair hearing. So that is that. Thank you very much for everyone who participated in the poll. Big up on yourself, manners and respect. Everybody, a manners and respect. Big up on yourself. Is a platform where we can engage in constructive conversations, and we're not here to agree. It's all about different perspectives, different arguments being presented. So you know anything, got people, big up on yourself. Rick Storm TV later. We're going to a little reason as always. You know, big up on yourself, people. Catch you up on the next one. You know, remember, drop a like on the stream if you have not yet done so. And you can also feel free to subscribe to the platform, you know, if you rate the reasoning. Big up to the people wherever you are from. We see people from all over the place, all over the world, checking in. So manners and respect to everybody. Big up on yourself.